Item number 17, Your Lordship. I am representing Suresh Shiv Sagar, petitioner. Kindly have it after 2 weeks, Your Lordship.
Item number?
17. 17.
Wait. Notice is already served. Counsel for the appellant is present. At request posted to 5th December.
Obliged, Your Lordship.
14, 15 and 16. GP for arbitration. Both counsel for the appellant and JP for arbitration is present at request of the counsel for the appellant. Post it to. I'll post it for the month ending. 23.
Item 26, my lord. But I am for the respondent in this matter, my lord. I have informed the appellant counsel, my lord. They are filing counter in this matter, my lord. Kindly 1 week time.
Amma, you are for the appellant? Counsel for the appellant is present. Counsel for the respondent appear through virtual mode. At request of the counsel for the respondent. Posted to 1st December. I'll verify whether interim stay is existing or not. Then I'll.
Let's may extend till then.
Yes, we have to verify whether it is existing because in some cases there is no interim stay continued. Yeah. Next.
Number 4, 37 to 44.
May it please, my lords, item number 41 and 42. I am appearing for respondents. Kindly 2 weeks, my lords. Appellants has already stay in this.
Counsel for the appellant. Let the other side appear, then I'll explain.
I informed other side, my lords.
Okay,
I
I
am
will.
appearing for respondent.
Yes. Next.
45 to 58.
And item 57, well. But in this
Item
matter, I
number
appear for
50.
the respondent.
Item 57.
57. Well, the appellant, sole appellant unserved. Well, the court, I think, has sent the notice. It has been unserved. R1 dismissed for default. Well, then the appellant has not returned unserved. Insufficient address. Well, there's no purpose in keeping this pending. Well, may at the due course of time may go through it, Malad, and dismiss it. If anyone appears, Malad may pass appropriate orders. It's under a workman compensation appeal.
Thing number 6, 59 to 74. And 775.
Management commission. We are paying $6 per applications and education for readings are already outside study. So last application was directed to post the matter today. It is not instead. But there is urgency that the lands are going to be acquired by the Prasapuram Reservoir without adjudicating the right because petitions have been written for the property. But it did not take much time, only 5 days. Already, rights your lords granted permission but not listed.
We'll post it on 16th, sir. 16th, 13th. If I post it for tomorrow, they may or may not be listed. We'll post on 16th. Monday we have holiday, no? 15. 15, 1-5. 15. That is the reason I said 16.
2015 that means.
Month ending veteran. Month ending.
42 item, I am the petitioner counsel, appellant counsel. In this case, my lord, stay until further orders is there, my lord.
In 48.
42 last.
42.
41 is connected.
You are the appellant.
42 I am appellant.
Actually, counsel for the respondent appeared through virtual mode and requested time. But as the counsel for the appellant is not available, I have not adjourned yet. Both are connected.
Yes, lord.
You are for the appellant.
Yes, my lord. 42 I am appellant.
I will see.
41 I am respondent, my lords.
I know you are respondent in 41 and 42.
Yes, my lords.
Let me see whether Kalyani Garu.
Yes, lord.
You are representing Kalyani.
No, my lord. She is ready. She is on the outside.
Okay. If she comes, I will let you.
Much of them.
In the result, CMA is dismissed, confirming the order dated 16/8/2016, WC 9 of 2013 on the file of Commissioner for employees' compensation, Assistant Commissioner for Labor. There shall be no order as to place. CRP 3237 of 2014. Civil division petition is disposed of by reducing the enhancement of rent for the subsequent each slab of 3 years subsequent to the first slab from 1193 to 311295 from 20% to 15% as indicated above while maintaining the order in all other aspects.
Interest.
20%.
Interest.
See, actually, I just wanted to find out about the interest also because nothing is mentioned in the order.
That's not, my lord. We have just paid the interest also. Interest is not given. Nominal interest, bank interest. is given.
And what do you say?
They have said no objection for that.
Because
They have filed cross aggression.
No, 6% or 5%, whatever nominal interest will be given.
Because my period is huge, my lord, 20 years period is there.
I'll do one thing at 2:30 again. I'll promise. Around connected. These two orders rendu 3237 and 3437. 2:30 Arun. Item number 2 and 3 are connected. You might have observed what happened, madam.
Yes, Lordship.
No one brought to the notice. That is the reason. And Mahinda Reddy Garu, it is brought
Yes,
to the
ma'am.
notice. It is brought to the notice of this court that the applicants have filed workman compensation case against the employer and National Insurance Company Limited. WC 8 of 2009 F was disposed of on 8/10/12 by the commissioner having not satisfied with the quantum of compensation. The applicants have preferred the appeal. The same
Yes,
was
ma'am.
disposed of by this court on 31/8/23. It is now brought to the notice of this court that the appeal inadvertently the new India Assurance Company Limited was erased as the opposite party to instead of National Insurance Company.
Yes, ma'am. The
So
Lordship may
issue-
recall
issue-
that order and issue notice to the National
Yes,
Insurance
that is.
Company.
Issue notice to the National Insurance Company Limited. Personal notice is also permitted. And
Lordship, for me, he has already served the notice, Lordship.
Okay, good.
So now the
These
thing
things
is
are happening, Amma. At least it should be brought to the notice of the court. Otherwise, we are
very much upset.
and
So,
personal notice of that. Then I'll post it to the shorter date.
yes,
You can
Lordship.
dispose of. 16 is okay. 16/11.
Yes, Lordship.
16/11 because they have already received the notice. It seems.
I have received the notice on behalf of New India Assurance Company, Lordship. So actually, this order passed doesn't bind me because I am not national insurance.
That is what. That's the reason we
So
are now.
now, what has to be done is that it is to be clearly mentioned that the order passed on the New India Assurance Company doesn't bind the order. As such, the liability will be automatically.
No,
goes
we
to-
have to again. They have to contest.
I may permit to take personal notice to the National Insurance Company.
Yes, yes, yes.
That would be better, Lord.
Much obliged.
Personal notice is also permitted.
Much
And
obliged.
on 16/11.
Okay.
Much obliged.
Amma, there's no representation for the appellant. Since date of filing of the appeal. In spite of opportunity, appellant has not submitted his arguments, despite the matter has been posted under the caption for dismissal. And as the case is of the year 2009, the CM is dismissed for non-prosecution.
Respondent 6, my lordship.
LC records अच्छे हैं. We have been adjourning this matter as we have not received the LC records. Item number 6. Not received. Huh? Await LC records.
Lordship, 1 point is to be added. The deceased who passed away actually was not appointed by the owner of the vehicle as an employee or anything. He just accompanied the person.
See, if you have the copies with you, we can dispose of the case.
Yeah,
Do you have it?
actually, I have that FIR. Last time I submitted the charge sheet and even the order of the lower court also. I submitted. The another copy I have.
Okay, keep that.
FIR, it is a charge sheet is.
The matter. Let the other side counsel come. We'll dispose of today. Because due to
Yeah, 2 points in and because he was not at all appointed, just like that he came and he sat with him. Nobody asked him to sit on the vehicle and all. And whatever compensation needed is already given to him.
Okay, pass.
Obliged.
For the appellant in this matter, my lord. As the case lordship wanted to see the policy copy, my lord, may I just pass on also.
Notices are sent. It is
Notices are served,
without
my
serving the notice, how can we?
lord. Notices are served my lord, by way of substitute service. Paper publication was carried out, my lord. Notice is served on all the respondents, my lord.
Police counsel for the
Appellant.
presentation for the respondent and come, unserved or instruction. And the cat will be, see, without service of notice, we cannot get the documents, no?
The IAs were filed, my lord, for paper publication, my lord, so by way of respondents 1, 3 and 4. By way of paper publication.
IA 1 of 2023 is already ordered.
Yes, my lord, they are ordered, my lord.
It's a wrong,
In fact, last occasion, your lordship heard the matter.
that is what, see, when it is posted under the caption for part heard,
Yes.
how can they put the IAs again? And also the notices not served and in the last picture intended. Well, in the wrong process.
In fact, all the IAs are.
Without serving the notices and without the counsel on record, how can we hear the case? And the case that has been posted as part heard also. Well, IAS and the mail petkochara. See, IAS are already ordered.
The IAs are filed to set aside the default order and seeking paper publication, right? Substitute service. That all.
23 is ordered on 8/2/23 itself.
Yes. Delay was condoned and all the IAs were ordered.
Petition have filed is asking permission. Substitute service. Loan complete. Yes, sir, number 829. 829. Okay, I can dispose of this case.
Yes, ma'am. Lordship wanted to see the policy copy, ma'am. I just placed the policy copy.
Yes.
Just to see, ma'am, if there is any additional premium paid for the
This appeal is
laborers.
filed by the insurance company.
Yes, ma'am. It's a case of death, ma'am.
What are the
4
grounds?
lakhs was claimed, ma'am. 2,52,674 was awarded. The only ground on which the appeal filed is that, ma'am, no additional premium is paid to cover the risk of the laborers. That's the only ground, ma'am. Lordship heard the matter, ma'am. Last time I cited judgments also. Lordship wanted to see the policy copy to see if there is any additional premium paid to cover the risk of the laborers. As the Lordship can see, that only one employee is covered. The driver, only driver is covered. Second,
Driver, say when insurance policy is taken, it is implied that driver will be automatically taken. One employee means one employee. In the premium for trailer is 375 rupees is paid.
Yes.
Additional premium. WCT employee 125.
25. Only one employee is covered. Only the driver is covered.
Driver is implied, sir.
Yes, ma'am.
Along, see, when policy is taken, automatically driver will be, it is taken into consideration that driver is also included in it. And later for a one employment, it might be is it a lorry or a tractor trailer?
It's a tractor, Millard. Tractor trailer. In fact,
Tractor trailer means
next
one
page it is
employee is
mentioned.
loading or unloading purpose.
True. But in this case, Millard, only one employee means the driver is
It
covered.
should be no, at least he has to mention it is whether driver or.
Ashu will see.
In some policies, they are mentioning it is driver, cleaner and other.
Yes,
Here it is employee. Employee means he may be a driver or a labor for loading and unloading purpose.
My submission is Millard,
Who
only
died
one
in this case, driver or the.
laborer died, Millard, not the driver. My submission is, Millard, the laborers are not covered. Not separate, Millard, additional premium needs to be paid, but to cover the risk of the laborers. Well, only the driver is covered.
See the second page.
Yes.
Second page. Additional premium for trailer is 375 rupees.
Yes.
Okay.
Yes.
375 additional premium has been paid. And furthermore, WCT employee 125 rupees.
Yes. Yes, that's not my submission. But premium is
Additional
paid
premium
only for one. Specifically mentioned.
375 rupees.
That is premium per trailer, Millard, but to cover the risk of laborers, Millard, additional premium needs to be paid. But that is the evidence which we have led, Millard. The judgments also which is cited squarely applies, Millard, to my case.
See, when there is ambiguity,
Lakshmi kindly see. My submission.
he has not written it is for the driver.
Last time, 3 సార్లు నుంచి ఎండార్స్మెంట్ వస్తున్నాను. Remove the name of Ratnam and
But Millard,
straight up పరిగెట్టారు.
there is no, Millard, my humble submission is,
Where all these things. Yes.
my humble submission, Millard.
Yes.
I totally understand. But if there is any ambiguity, Millard, I understand. But the policy is not very clear that it covers only one employee.
One employee.
The driver is
driver or a labor.
I understand that. To cover the risk of labor, that's the reason last occasion I cited these judgments. But this honorable court also has taken a view that unless and until additional premium is paid, the risk is not covered.
Additional premium of 375.
Must be a separate contractual liability. And a separate premium needs to be paid.
Let me see the evidence of you. RW automatically be transferred to new owner when he denied basic premium covers other premium as well as there is no need to pay addition. Now IMT 25 to be paid addition for every employee and then only coverage will be. And since he accepted basic premium. He accepted that basic premium is enough. Witness added that statutory liability is limited to third party liability. He said that he is not aware whether statutory liability defined under 147 also includes liability of third party employee as well. He accepted that payment of additional premium is required to cover the contractual liability under 147, but not provision 1. He denied that basic premium includes premium employee as well as third party. He denied that under statutory which will not actually perform with this premium. Therefore, working on lorry is not an employee, only driver is an employee. He also accepted
Yes.
that there is no mention in Exhibit B1 policy that 25 collected for only for driver.
For driver, yes, but that will it is their admission.
And
But
it should need.
That's my kindly see.
Additional pay
para
of
16.
additional pay he denied as per science of condition and he denied return.
So far as the transfer of Millard policy is concerned, we are not pressing on it. Automatically, once the vehicle is transferred, it is deemed that the policy is transferred.
Page number 7, they learn tribunal.
Yeah.
Came to the conclusion further it could be seen that premium has been paid to cover the risk of one employee under the act. The word employee covers all type of workers employed by the insurer.
That's the reason that I cited the judgment.
Yes.
But the evidence of
Yes.
that the insurance company is not only
Court officer. I need judgment and it is.
the last occasion I gave some judgments. three judgments. But the two judgments are made, recent judgments of this honorable court, Milad. Last may kindly take Milad the judgment Milad passed by the Milad Justice Milad Lakshman. That is Milad also arising Milad under the Workmen Compensation Act. But the other judgment Milad is under the Motor Vehicles Act. But the view taken by this honorable court is Milad para 8. The pay and recover was also not granted in this case, but the other judgment in para 12 it is relevant.
In this case, there is no reflection of payment of additional or special premium to cover the contractual liability in the present case.
Yes,
You have filed.
Yes, Milad.
But in our case, a premium has been paid.
That is my submission. There is no additional premium is paid. My only submission is very simple. But as per the policy, Milad, only one person is covered, Milad, that is a driver. But the deceased is a labor traveling on the tractor trailer, Milad, who is a labor, but for whom no additional premium was paid. That you may kindly consider. Milad. As
I will say.
Yes.
There is a change.
Even as per the policy, Milad, only one employee is covered. May kindly allow the
The
appeal.
date heard the appellant. A judgment posted to 1711.
Right.
Sir, 6, one minute. Item number 6, SAV Ratnam garu.
Yes, Milad.
Counsel for the respondent has brought the documents, copies.
Yes, Milad. In the FIR, I have seen that FIR also, Milad. In that also it is said that he was sitting on the engine and mudguard. That is our case. He is not supposed to Milad travel on the mudguard. That is our case. If you I have it on 14th Milad, I will submit them.
Actually, but no one appointed him as an employer. Nobody asked him to sit over there. He was nowhere concerned with the owner of the vehicle. Nobody asked him to sit, or nobody asked him to give any company or something. His will and wish of the person who was deceased. With his own interest only he came, with his own interest in his hat on. Nobody will do an accident in that place, and there was seen that it's rash driving and all. Lordship, it happened 12 years before, where the place was Jagannathapuram was with no CC roads and all. It was just muddy. He didn't drive rashly also. He just turned turtle in the turning point. The person who was deceased was not employed. He was not working under the owner of the vehicle, and that day it was going for agriculture purpose only. This is what happened, and I rest with this.
Milad, I will submit the judgments, Milad, wherein Milad, the Karnataka full court judgment is there, wherein Milad is not, one should not Milad travel on the mudguard, and if it is so, then Milad is not entitled to compensation. Milad, considering the said judgment, Milad, even Justice Lalita Kanigante also Milad allowed our appeal in previous, in one matter. Your Lordship, Milad, have it, Milad, 14th Milad, I will submit.
Compensation which the deceased family has to get, already they got. 5 lakhs compensation he got already. They were not employed. How many they can give in lordship? He was first of all not an employee of the owner of the vehicle.
1411.
As there is stay by his uncle,
1411.
he cannot withdraw the amount, though we have deposited under section 30 of the Millard Act.
Okay.
You'll actually have it on 14th Millard.
1411. Yes. Item number 8.
8
Yes, Sriharnath
also will actually have it on 14th Millard.
Garu Sriharnath Garu is ready to submit his arguments right now.
Actually, Millard, I have argued this matter, Millard, on the last occasion. There is no employee relationship, Millard. The owner who filed the counter, in his counter, he categorically stated that Millard he is not the employee of the Millard. That's why anyhow, Millard, you will actually have it, Millard, on 14th Millard. I am now handicapped with the bundle, Millard.
I think not by the if you are noticed, page 14, AW2 is cleaner of the vehicle that eyewitness examined there are 20 8th line further the cleaner of the same vehicle was traveling to the vehicle along with the deceased driver on fateful day came before commission and reports that the deceased was working as a driver on the same water tanker and as part of the duties while driving a safe vehicle met with the accident and died due to the injuries sustained to the accident. But that's what kind of there. Issue number 2. Issue number 2. After one accepted the opposite party obtained an insurance policy in respect of the water tanker, so the second party has collected the premium to cover the risk of the 2 employees under the MDA. The cleaner and driver they have collected additional premium. This was the cover the risk of the employees. Moreover, the eyewitness will be cleaner of the same vehicle. Clearly stated that we are working as under the opposite party one.
1411. Not for judgment. She wanted to submit some more.
Already she submitted the argument.
Same caption, part 3rd. 1411. Next. Counsel for the respondent is present. At request of the counsel for the appellant posted to 21. Yes.
May I please read the motions? IA1 is seeking condemnation of delay in representation.
This will be ordered representation.
In main up,
Yes.
I request your lordship's order notice. Suit is filed for declaration of title and perpetual injunction. Right?
Suit for recovery of possession.
I'm sorry, Your Lord. It was declaration of title and consequential recovery of possession and also grant
But
of
you
main
have
profits.
mentioned in the petition and the recovery of possession.
Yes,
Hmm?
I'm sorry. It was
Yes.
declaration with a consequential recovery of possession and also grant of main profits. However, the suit was dismissed without framing any issues and without considering the statements and evidence. Even that.
Yesterday you have read now.
Yes, ma'am. It was a similar case.
Okay.
However, there is no IA seeking anything.
Issue notice to respondents.
I may be permitted to take out personal notice.
That's not also permitted.
Oblige.
Posted to 6/12.
Oblige.
Millard, I am representing B. Rajshekhar Millard. Kindly, this matter may be taken up next week, Millard.
I am appearing for the respondent, my lord.
Yes. Counsel for both counsel appear through hybrid mode. At request of the counsel for the appellant posted to 2811.
Obliged.
Well,
You are representing the revision petition. Revision petitioner. R3 and R4. Yes. Counsel for the revision petitioner is present. No representation for the respondent on call. For filing counters, if any, in IA 1 of 2020 and 1 of 2021. Posted to posted to 512.
Let's with the lapses permission, but item 13 to 17, there is a batch, but
Huh?
item 13 to 17, there is a batch of CRP and content,
They're all adjourned, no? Adjourned to 2311.
but not informed.
Both counsel are present. P. Krishnamohan Garu appeared online. You are representing? Whom you are representing?
K. Kiran Bhai.
Who is Kiran?
The batch.
Counsel is P. Krishnamohan Garu.
My apologies.
And GP for arbitration. Both counsel appeared.
Yes.
Whom you are representing?
But, item 13 to 17.
No.
My apologies, madam. I just very.
That's okay.
1924 now Revelika court variable forum other one.
No representation either side.
Sorry, madam, item 19 onwards back.
19, 20, 21, 22.
Madam,
Yes, yes.
but I appear for the respondent in this matter. For the respondent, madam, I have filed IA 4 of 23, madam, seeking for being mentioned.
Which matter?
This madam, 19 to 20. My
You're clear now.
Yes,
Okay. So you're representing the
madam. For the second respondent, madam,
second respondent.
madam, our names are not printed. However, madam, I have filed IA 4 of 23. But,
For being mentioned.
yes, madam. In order dated 3/4/2023, but there is a typographical mistake with regard to proceedings, date of the proceedings. Madam. But, page 12 of the application, madam, IA 4 of 23. Initially, when the CRPs were filed, there is an interim order granted in their favor. Subsequently, we filed vacate minute. Vacate orders have been vacated by virtue of this order dated 3/4/2023. In this order minute, page 12, typographical mistake crept in minute, page 12 minute, second line by page 1-2. By virtue of the proceeding dated at 22/12/2020 is printed, but in fact it is 4/3/2023.
Okay.
But we are only seeking typographical mistake. 4/3/23.
The date has to be modified.
Only the date has to be
Who
modified.
is the other side counsel?
I am appearing for
First respondent.
first respondent. The petitioner counsel is Pravalika Gaud Melod.
In IA 4 of 23, 4 of 23 is filed by the
Yes,
revision
for the second
revision
respondent.
petitioner only.
Yes.
For
No,
what?
Second,
for the second
second
respondent.
respondent. Then Pravalika Gaud.
Pravalika,
We do not have the copy of the modification petition.
No, that was served long ago. Man. It was filed.
informed her last night about this, my lords.
Second one, we do not have the copy of modification petition. We don't know what is.
Well, may I request for a password? I'll serve copy on him, only for being mentioned application.
Last.
In fact, that was served. Thereafter, only it is numbered. The Lordship would see there is an endorsement to that effect by the petitioner counsel also in the application. In fact, my lord, it is only for being mentioned, my lord, I am only seeking correction of typographical mistake in the order.
That is okay, that can be done. But they should receive the copies, no?
No, copies are served long back, my lord. In the month of October itself, these applications were filed. After obtaining after serving copy, after obtaining signature from them, my lord, we have filed it in the registry.
Hmm.
On the last occasion also, my lord, someone from the petitioner council appeared, my lord, and they sought adjournment.
And do one thing, please share the copy.
It should be passed over.
Okay, or else I'll post it because.
My lord, for being mentioned application, my lord. Small application, your lordship may kindly consider.
14th.
14th.
Clerical thing, my lord.
My lord, it can be allowed, my lord.
Tuesday, my lords may have it, my lord.
14 is Tuesday.
Yes.
In the meantime,
Yes, my lord, I'll serve one more copy and we will learn it.
the matters are connected till 24 or?
Yes.
Huh?
All are connected.
From 19 to 24.
Yes.
All the matters are posted to 14 level.
Representing on behalf of the petitioner, when actually we are filing wakalat, lots of parties. On behalf of case.
Actually, it's a chief notice there based on the
Filing wakalat.
justice notice. This case has been posted here.
Yeah, it was allotted to us, my lordship. Filing wakalat.
Council is there, no? For whom you wanted to file wakalat?
K. Sharath is
Huh?
right now. K. Sharath is justice right now.
Okay.
On behalf.
You are going to file or your
My senior.
your senior?
Yes.
Sri
Krishna Kishore Kovur.
Sri Akhilesh, representing Sri Sharath, stated that who is going to file
Krishna
wakalat?
Kishore Kovur.
Krishna Kovaru is intent to file wakalat on behalf of the revision petitioner. Hence, at request posted to
Lordship may give 2 weeks of time.
and posted on 6th December.
Much obliged.
Look, item number 26, my lord, extension of entrance.
You are representing?
Appealing. Matter is urgent that you have stated courts with regard to extension.
In the morning you stated, no? Extension is there. Okay.
Yes, ma'am.
I have already adjourned the matter to 1/12. So interim orders granted earlier are extended till then.
So in this matter, on the last occasion, it was adjourned that we were not served.
Which one?
27, item 27, my lords.
Item 27.
Seven. They did not serve copy till date, and morning their senior has informed that they'll give a copy as today. Lordship might take it any day in the next week.
As per mine, I was informed that they will file counter this.
See, without serving the copy.
Last occasion, their senior Shreyas appeared in this matter, and that day it was adjourned that he'll serve a copy and I'll file a counter. It is for the restoration petition meant.
You serve copies immediately.
So we'll give any day next week. It was dismissed for default, my lordship.
Council, both council are present. Shall I mention that on the precedent sheet by giving
Lordship might
direction?
mention because last occasion that
It's not good actually.
We'll file.
last occasion it was adjourned and say.
Okay. So at request of the council for the appellant posted to 6/12.
Much obliged.
28.
Lordship request for the 2 weeks time. Request for 2 weeks time.
Both council are present. At request of GP for arbitration posted to 7/12.
Last bit of combination, I guess.
Okay. Ready, yeah? Are you ready? Oh, both counsel are present at request of the counsel for the appellant posted to 29.
Lordship, I am representing the counsel for the appellant, Lordship. Senior left to the Suryapet court, Lordship. Lordship may kindly have it next week.
Counsel for the appellant is present. Counsel for the appellant, JP for arbitration is present. At request of the counsel for the appellant posted to 7/12.
Date, Lordship.
7/12.
Okay, Lordship.
And these notices are already served, R1 served, R2 served, R3 served, R4 served, proof of services filed. At request of the counsel for the appellant posted to 7/12.
Let's are preparing for the respondents, sorry, for the petitioner. Let's have filed an additional document evident petition. It was returned, I have resubmitted it.
The fact remains in like this one. But these issues which is filed as an additional document is not at all the pleading before the trial court. And absolutely those documents are not essential. They are relying upon certain document executed by my father. And that documents is not in connection with this eviction petition. There is a concurrent findings. Considerably, they have wait for 5 years. Now they come with an application. What I have noticed, because notice is not given to me, is that under Order 41 Rule 27, they want to bring a document which is no way in the pleading of the trial court or appellate court. And under that guise, they are filing an application that is returned, again they will refile, again there is a delay for some times.
The question
That
now.
will be taken up on the Monday, Milord. Whatever the counter, I will file the counter. My friend, other respondent also will file the counter. Let it be taken up and decided.
But there is no IA.
But it's a
Order
file.
41 Rule 27 IA is not.
They have sent a copy to us.
I've filed.
They have not
In fact, I have the.
They have
No,
sought my
it is not in the.
I have the SR, it's already on record. 87286 of 23.
My friend said it returned, my lord. It has not.
No, I have resubmitted it, Malik. I have resubmitted it. In fact, the number which I am quoting now is the resubmitted.
Absolutely, those documents cannot be taken at the second appeal stage. Raising an issue which is.
First appeal.
These are subsequent event that I've developed.
There is no question of event.
87286 of 23. Yes, sir.
And whatever we not being a daughter, I am not party to that, those documents, what they have filed right now.
Otherwise,
Why those documents are not filed before the trial court?
When the petition was filed before the trial court, there was nothing as such. Now these are the subsequent developments which have taken place. Now the question is, what they are raising is that no rents have been paid. Now subsequent to that there was an agreement between the father of these petitioners and our client Malets, based on which we have filed these documents. Let them file a counter. We've already served copies. If the court finds it sufficient, that's be taken on record.
That application is not in the record right now. And it is also not reflecting on the cause list.
Absolutely, both the parties have been argued on merits. Now, two courts has come to a conclusion that there is nothing on that. The plea which has not been taken before the trial court is a legal question that cannot be taken at the second appeal stage. They are saying that there was an agreement. There is no reason as to why they have not been filed and taken a plea that they are coming by virtue of an agreement. Absolutely, that is not the part of record before the trial court as well as the first appellate court. Now, at this stage, they cannot file Order 27, what my friend is saying. After 5 years, keeping it pending without paying the rents, now they want to continue further by filing an IA. But both the parties have argued, senior counsel has come, they have argued, nothing remains in this appeal. There is no substantial question of law which can prevent them to proceed.
In fact, the application is on record, on the website, in fact, with the very same number. It's 7
Both
to
the grounds which is being taken by the petitioner in the lower court, my lord, has been proved.
Is there? Yeah. It's not available in the record.
Well,
If it is available,
it is reflected.
it would have reflected in the cause list, no? It's not in the cause list also.
Well, maybe they've put it pending for scrutiny because on the very website of the High Court.
Last one. Learn counsel for the
Revision aspect, I would just make a suggestion.
yes.
Let them be directed to deposit the ideas of in the court. If
Will
any-
dispose of, sir. Main CRP will dispose of.
Because it's almost 3 years as of now, they are not paying any rents.
Even order 41, rule 27, no separate order will be passed. Okay. We have to see whether to look into those documents or not.
Well,
Then
the very subject property
Mm.
which is in dispute. Well, the very same property, in fact, has been transferred.
For specific purpose, have you other remedies? If
that
that is the case, a very fictitious document, whose signatures are there, the document has been served. So on put on face apparent can look into the signatures, they do not tally with the signatures.
I filed 2 documents. One is the agreement of sale. In fact, that is registered document. I've already filed, I don't know for what reason it is not on record. That is apparent on the face of the record that the first document which I filed is registered document.
Why
Malad,
it is
subsequent
filed
document.
during the trial in the first appellate court and why it is filed after the 5 years?
Because that is the subsequent development. Subsequent development.
Over, plea is being taken, all the points has been argued. Matter is for disposal. At that point of time, it is being filed, which is a forged and fabricated document.
both counsel are
This is directly registered to.
both counsel are present. Learn counsel for this.
Arya Ashita, petitioner.
Monday, 20.
Right.
And the principal with the answer, not a question.
You are representing Anasuya. No representation for the respondent on call. Counsel for the revision petitioner is present. It's posted to 612. 612. Next Friday, Lash. Counsel for the appellant revision petitioner and GP for arbitration and respondent number 3 are present. Why they have separated again? 3 to 5. 1 to 6 3 to 5. 1 to 3 to 5. 1 to 5, Amma. Respondents 1 to 5.
It's better it's a file.
At request of the revision petitioner posted.
2 weeks.
First week of December.
Yes.
6/12.
Right.
You are representing the revision petitioner.
Leadership, I am for the responding item number 35. Leadership, this is matter regarding the mentality of this CRP. You have already heard. I have physically present on the last date of hearing.
Yes.
And they are lingering on the matter on one pretext or the other on the several months and more than 10 adjournment they have taken. And the leadership, their tactics is first time passover, second time adjournment.
Yes.
First call
He's
will take
ready.
passover. Then leadership.
He's physically present and is ready to argue now.
Yeah. Then we continue.
No, continue.
Hello, so we are come to the appearing in 11 correct? Short parcel will want to find. Before that, short parcel.
You initiate.
Yes,
And
leader.
your senior will continue. You should take advantage. Junior council should take advantage. Then
The senior council will also this matter. Parcel before lunch would also the
you submit the facts of the case, and your senior will come and argue the. I'm giving you an opportunity. I can't help it.
Leadership,
Short pass.
leadership, may I continue?
His senior is going to come now. Is requesting short pass over only.
Then may fix the time at any fixed time, 2 p.m. or 2:30 p.m. Any fixed time, leadership.
Okay, 2:30. So that he will attend other courses. 2:30.
Okay, 2:30. Yes. Thank you.
Yes.
This petition was filed also. It was sent to the respondent also. After the sample packet.
Jagdishwar Reddy, Dinesh Patil.
After the petition.
Yes. No representation for the respondent. It is first time it has been listed first time in this school. No representation for the respondent. Counsel for the revision. Counsel for the revision petitioner. Counsel for the appellant is present. You are requesting time?
Petition may be ordered also.
How can I order? Other side counsel has to file counter and other side counsel is also not available. And furthermore, it has been listed for the first time after 2019. Posted to 4th December, 4/12.
Municipal return for the password.
37.
Password.
Password.
Counsel for the respondent.
One minute. With the item 37, proof of service filed. Proof of service. Yes, 38.
8 and 39
Both are connected. Okay.
Maybe posted after 2 weeks, my lord.
Who is requesting time?
He is
Appellant or
requesting
the
for
respondent?
1 week.
for next week. Any calendar.
Both are requesting time.
There are 2 weeks.
You are the appellant.
Abandoned.
Should my interim orders existing or not?
That there.
Give me the placement. When the orders are passed?
On
5th October.
5th October.
yes, ma'am.
Suspension. This person.
It is up to
It's
9.
only a suspension of the judgment and decree.
Yes, my lord. Till 9/11. Till 9. It's there, my lord.
No stay is pending.
The suspension itself is up.
It is only suspended.
Suspended to the right.
Suspended till 8/11/23.
Yes.
After that,
What is it now?
But 9/11.
both counsel are present. At request of the counsel for this, at request of both counsel, posted to. It is 21 matter, no, I'll adjourn to a longer date. Is there any urgency?
No, my lord, no, I get
7/12.
obliged.
40. Appearing on behalf of counsel for respondent and
Bhujangarao.
I am representing Masoon Reddy. It's both parties have settled and they want to refer to the local adalat.
Settled, huh?
After 20th, Milord.
Okay. Council, both sides, both council are present and stated that the matter has been settled. Hence refer the matter to Lok Adalat.
Recording up.
And the parties have to appear before they have come.
Parties will hear.
రాజీ పడ్డారండి కేసు ఇద్దరు కూడా
ఇద్దరం రాజపడ్డాం మేడం. ఈ సదరణ ఉంటే అక్కడ మన లోకల్ రాసుకొని చేసుకున్నామని అనుకుంటున్నాం.
ఓకే.
ఈ తర్వాత తనే ఒక 2-3 సార్లు రాలేదు.
ఈసారి వస్తారుగా మీరు?
నేను ఇంతకుముందు వచ్చిన మేడం.
ఆయన వెనక రాజీ పెడితే మీరు లోక్ అదాలత్లోని సెటిల్ చేసుకోండి, అవార్డు పాస్ చేస్తారు. డేట్ ఇవ్వక్కర్లేదు, రిపోర్టులు కదా లీగల్ సర్వీసెస్ అథారిటీ. నెక్స్ట్
41.
ఇందులో మార్నింగ్ వాళ్ళు రిప్రజెంట్ చేశారు.
Wait, please, my lords. I am appearing for respondent number 1 and 2 appearing virtually.
In item number
41. 41, I am appearing for respondent number 1 and 2, my lords. Senior counsel Vedla Srinivas sir is appearing for me. He is held up in Amravati today, my lords. Kindly next week, my lords, any day.
I'm other side counsel also
Lordship, I am
time.
for petitioner Lordship, item number 41. Actually, senior counsel will appear in this matter. Kindly pass over Lordship.
In the morning, someone has represented actually they
Actually,
insisted
we are
for
for-
date, but I have not given date because counsel for respondent is not available.
Yes, actually, I am petitioner Lordship. I am appellant.
So respondent. Someone
Respondent.
represented on behalf of the appellant.
No Lordship. Actually,
Kalyani-
yes, I am.
Somebody represented but I have not.
He appeared in 42, my lords. Both are connecting matters, my lords.
42. Yes, Lordship. Both are connected matters.
He appeared in
Ramchandra garu. Yes, Lordship. But actually, Lordship, Kannondili petition will argue the matter. Kindly pass over Lordship.
But other side also has the.
I'm sorry to interfere, my lords. I am appearing for respondent number 1 and 2. Even my arguments also should be heard, my lords. Vedla Srinivas sir is appearing for me. He is held up in Amravati, my lords. Any date, my lords.
Lordship, today we will argue the matter. Let them argue next week whenever Lordship. That is better, Lordship.
Let both
Actually,
seniors be
last-
present on the same day, my lords. We are also ready.
It is very difficulty for us, Lordship.
Only 1 week, my lords, because of this.
Is there any urgency 23 matter?
No, my lords. 42, they are having stay, my lords. In the
Actually,
same time.
42 is stay is there, Lordship. 41 is no
same
stay. That's why
judgment.
Kannondili petition is there. That's why we'll argue on
That is
Kannondili.
also against same judgment, and in that there is interim order for until further.
Kindly
my lords.
ask interim orders, Lordship. Otherwise,
There are 4
Well, let them
condon delay petitions are there. 4 LR applications.
yes,
are there,
Lordship.
4 set aside abatement are there.
Yes,
Yes,
my lords.
Lordship.
11 applications.
So
Appeal is
there are
filed.
number of applications pending in this case. And we
Since
do not know
1300 days
because
delay is there,
you
my
are
lord.
only respondent number 1. There are other counsel also. K. Ramchandra garu is there. Govardhan
Morning
Reddy
he
garu-
appeared, K. Ramchandra Rao garu.
Govardhan Reddy garu is there.
I am Govardhan Reddy, my lords.
He is Govardhan Reddy, Lordship.
Okay. But I can't see you. At least switch on your video. Govardhan Reddy garu.
I'm sorry, my lords. I have less video connection. Internet connection, my lords. I'm sorry.
Lordship, kindly pass over, Lordship. We'll argue on condon delay and set aside petitions, Lordship. Let them argue next week. Actually, we have.
Have you filed counter and condon delay?
Yes,
Govardhan
Yes,
Reddy
my
garu?
lords. I filed.
Yes,
I
you have
filed.
already
Other
filed.
respondents
Okay.
should appear, my lords. There are so many respondents.
we filed substitute petition also, Lordship.
Only
See,
for
in
4
in
days
their
there is
absence,
no
because
urgency,
not only Govardhan Reddy garu, but Ramchandra Rao garu is also there.
He'll come, Lordship. Pass over means he'll come. He'll attend.
You can appear online again. Govardhan Reddy garu.
My lord, senior counsel Vedla Srinivas sir is appearing for me.
My
He is in Amravati, my lords.
Okay.
Tuesday.
16/11.
Tuesday, my lord. 16/11.
Tuesday.
Okay, my lord.
Tuesday, Lordship.
Okay, 16/11. Tuesday we have many other cases.
Deeply obliged, Lordship.
Next.
Deeply obliged.
Yes, my lordship.
Hmm.
Reports are
Hmm.
personal notices are sent, and still we have to find, we have to get acknowledgement letters. We have to find person.
The notices and not yet written, observe verification. Notices and not yet written. And Venkateswarlu has filed. Open it for R2, R4, R6. See, notices for R1, R3, R5, R8, 13 to 16 should name in.
And actually, there are few notices which were not written and few were served, but for none, proof of service is not filed, my lord. Let them file proof of service.
For getting all the acknowledgement letters, we will find to person.
You have to file proof of service,
Yes,
ma. Whether notices are served or not, you tell me.
Sir.
They have returned unserved actually. Returned unserved for reasoning. Oksara, give those notices. Returned unserved. The reason and notices returned unserved. Returned unserved to reason mentioned here.
Yeah, the last occasion they have not.
Vishwa. Anyway, file proof of service so that we'll have. Both counsel are present at request of the counsel for the appellant posted to 23 matter.
Lordship might give 1 month of time so that they will also file all the proofs.
812.
Much obliged.
In the meantime, for filing proof of service posted.
Lordship might record that for filing proof of service to the docket order.
For filing proof of service. For filing both counsel are present at request for filing proof of service by the appellant posted to 812.
Much obliged.
45. Wages are pending. The number 1 is No.22, the petition. Petition number 1 to reflect on petition number 2. Will stay the petition.
With the GPA, this can be allowed. GPA.
1 of 23.
IA 1 of 23 is ordered. And you can
Stay petition. Stay of all.
yes.
That's the apparent report is last year. Finally, we have 22 E3 to the 2016. The clarification. That was dismissed on the 31st July 22. Everybody dismissed on the clarification, they have prepared the first of them. Facts of the case is concerned. In the spot number 2, with the decree order, as filed OS number 98 of 2015. And after decree against the respondent number 2, with the decree on 14th December 2015. After the decree has filed an MP, after the decree. Also, for the attachment of the people petition of property. And also, property was attached on 31st July. Property was attached on the 29th August. At least the attachment, the petition last before this court, they have provided clarification. Stating that the petition should tell property is the access to property. 2. And also, they have provided a suit for approval of 2008 super partition. This is getting number 2. And after the degree on 21st October 2021. Well, then
See, warrant was already executed and report was made. Warrant was already executed. See the order. Page number 17. And sale papers are also filed.
Papers filed as and when the property was not sold for the class. That was posted on 30th of Monday.
What is the property?
Removed property.
Removable property.
Posted on 30th for sale of public action. Property was attached in the EP on 15th March 2000.
Sale papers were filed coming for settlement of terms by the time an EA was filed as per the relative partition.
The main condition of the petition that they already filed a suit for partition in respect of the property. The suit was decreed in their favor on 21st October 2021. By allotting the 1/3 share into the petitions 1 and 2, also 1 share to the 1/3 share to the petition number 2. Basing on the decree, they have filed the claim petition. The High Court has dismissed the EP only on the ground of application portion of the order. Page number 20. And number 20, page number 20. And seeing the strength of the evidence of the claim petition, the JD has already attached to the property and the exclusive property of the JD number, wherein the claim petition are no way concerned with the admit people are not binding on the EP proceeding. The nature of the property is exclusive property of the JDR. Having knowledge of JDR is concluding with this children brought into the existence of the present EA to knock away the property from the hands of DHR for recovery of the The present is only that in matter. The claim petition of the petitioner was only discussed on the ground that there is collision between JD number 2 and the claim petition. And say that the civil court, the regular applicant civil court has possibly for partition by allotting the 1/3 share to the petitioner. That is exhibit P2 and P3. The High Court has not considered the decree, simply saying that the recovered party to existence only the collision of JDR as the claim petition. As on today, the decree was not satisfied by any complaint court. It is admitted fact as on today, the partition decree was passed and allotted the 1/3 share to the petition number 1 and 2, and also 1/3 share to the respondent number 2. And as on today, the decree was still in force. The same is not satisfied by any complaint court, or that any person has prepared any appeal or challenge to the decree. Subject sale is made on the JD number 2. Without considering the decree of partition, the High Court dismissed saying that there is a provision of the JD number 2, the JD and the claim petition. See, also see in the meeting. See page number 29. That is EP copy. Page number 30. 29. EF now. The value of the property they have shown in the EP 50 lakhs. The EP was filed only industrial per group is 19 lakhs 64,000. Actually, the value is more than 1 crore. But EP was filed industrial only for an amount of 19 lakhs 64, that is not more than 20 lakhs. But they have shown the property value 50 lakhs, the EP itself. Oh, that's a open market value. The value of property is more than 1 crore. Both petitions, certainly they will get 1/3 share each for the property, and the value on the property 1/3 is allotted to JDR. And the value of the property is more than 75 lakhs 1 crore. The EP amount is only 20 lakhs. The EP amount of 20 lakhs they want to sell the entire property of more than 75 lakhs. It is subsisting, passed by the complete civil code, but it not be dictated. How can we try to pass an order saying that what it to exist over the pollution of the parties? Only we consider this. EP amount is only 20 lakhs. They themselves show the market value is 50 lakhs. Actually, the open market value is more than 75 lakhs. Even the value also, we will get the 20 lakhs out of the property. Retail amount is more than 50 lakhs, 60 lakh, that is entirely different. The degree amount itself is 20 lakhs. Once the property is sold, very different from the traditional. Get the 1/3 share of the properties. Who is the none of the owners of the area? If you want, they are doing sir. Judgment and it is part in partitions.
We issue notice to the respondents. IA 1 of 23 is already issue notice to respondents. Report at
If you have 20 days, the petitions, they have one further consideration.
it is again sale is on 20/11/23.
After sale, the portion by the
13/11 for proclaim and sale of AP scheduled property.
20th portion.
What happened on 13/11?
Not done.
No?
I think that's the Monday coming.
Yeah, 13.
I think on sale that.
Okay. And they have issued the paper publication also transfer. Not date is post it. 20/11. 20/11. And the stay. I had to ask. Next.
Representing Ashok Reddy Santala, my counsel for the appellant. We are requesting short date, my lord, to say, my lord, senior is set up in another court.
Yes, your counsel for respondent.
Appearing for counsel for respondent.
Both counsel are present. At request of the counsel for the appellant posted to 23 matter, what is the urgency?
My lord, this is suit appeal against the suit for permanent injunction, my lord. Now they are trying, respondents are trying to interfere with our question, my lord. So there is a little bit urgency.
Suit is dismissed.
But my lord, till this was also there was a injunction, my lord, after hearing both parties.
That order merges with the final order. That's a principle of.
See, respondent counsel are not denying it, but there is a little bit urgency on our side, my lord.
Okay, 1711.
Sorry.
1711.
Instead of 17th, your lordship may have it on 21st, your lord.
My lord, that will be.
My lordship, my humble submission, already suit is dismissed, only one ground. They are trying to interfering illegal construction also doing. We kept many objections, only on simple ground, the suit is dismissed. It is submitted that
If
kindly.
he wants to argue, I will also ready, your lordship. If he's arguing, I'll be ready now.
Any short date, my lord. Instead of saying if it's not, the other one is not there.
15 is okay.
Yes.
15. 1511.
So,
47, 51, other signs.
No representation either said on cause. Or the adjournment say 2009 matter old. 11. Eight adjournments 2009 matter. Why we are still keeping? Give me the please. Arbitration case. A perusal of proceedings sheet shows that there is no representation from 26/6/20, 26/6/23, 7/7/23, 7/8/23, 16/8/23, 12/9/23, 29/23, 6/10/23. As the case is of the year 2009 and the appellant has not submitted arguments despite opportunity, the CMA is posted under the caption for dismissal on 16/11.
Medical bills are not considered. Drivers he spent 1,30,000 for treatment.
LC records not yet received. If you have a copy of the documents, you can furnish. You're not having? Then we have to wait for the record. Both counsel are present. Await LC records posted to. We are getting records every time. I'll be saying we are getting records from even from Adilabad, but not from Hyderabad. I do not know this. Every time we are adjourning the matters. Posted to 22.
It should be taken up on 17th.
You are representing?
M. Vidyasan.
At request of the counsel for the appellant. Give me that question. How many adjournments are taken? They're all old cases and have been posted for final hearing also.
Senior is out of session.
Record, I'm going to case could even interest. It's an endowment case. Concept of the appellant was taken. 5th December. 5/12.
Public.
Both counsel present. GP for arbitration. Hmm? Item number 50 is M. Lakshman. M. Lakshman Rao.
It's a double claim.
Hmm.
First, like I understand the material claim first, but the index of the CMB.
Yes.
WC 1/2009 is the tuned WC method is present. Let's seeking compensation for the death of the same person. Some other people have filed WC 33 of 2009 with not the Commissioner of Labor somehow.
Where is it?
In the material table. Index of the is
So running index.
in the running index.
The running index page number.
Page number is not mentioned in our copy. Serial number 4 might have placed and WC 33 of 2009.
It's not there on the index.
Indeed.
12 to 17. Page numbers are there. 12 to 17. 12 to 17. 12 to 17. WC 33 of 2009. Jayamma Narsimha Rao. Narsimha Rao. And this is.
Subsequently, we have filed a transfer CMB seeking the transfer of this WC 33 of 2009 to Hyderabad Labor Commission Commander. That WC bundle of 2009. It will get more than 9. Ultimately, whether by transfer CMB was pending. This WC bundle of 2009 is said. So we have filed appeal against this WC bundle. Like now we need to get it settled with regard to the WC 33 of 2009. Well, if it is withdrawn manner, they will proceed here. But if it is adjudicated manner, we will return the case.
I think the disease might be having two whites. Because he says no. Tirupatama, wife of Lakshmi Narayana, and Jayamma, wife of Lakshmi Narayana.
2 weeks.
Counsel for the appellant is present. No representation for the respondent and crops. At request of the counsel for the appellant post written. 1st December.
Even records and
In the meantime, this is directed to call for the records from the counsel. No representation, no representation, no representation. Why you're not giving the claim? When you sent to choose that. It is filed by the applicants. Yes, sir. No representation either said on call. It's posted. 4th December. Hmm. Both councillors present. 17 levels. At request of the council for the appellant. Seventeen level.
55. Same.
17? 1712.
Previous map.
Have adjourned to 1712.
Yes. Item number 28.
Today? 28, huh? Item 28. 712, Amma, not 17. 712.
This was.
Okay, 712. The council name there is sole appellant notice sent not yet returned. R1 served, R2 served. No representation looks served. Sole appellant notice sent not yet returned. ఎట్లా మా జిఎంఎస్ స్టెప్ మార్చేస్తుంది పేజ్ మారగానే ఎవ్రీ టైం ఇక్కడ నోటీస్ ఉంది కదా నోటీస్ సెంట్ నాట్ ఎట్ రిటర్న్ స్టెప్ మార్ కౌన్సిల్ ఫర్ ది రెస్పాండెంట్ is present. Notice sent to the appellant is not yet returned, hence posted to Nalgonda 2911.
My lord, respondent counsel requested next week. We already informed our side. We informed our side.
You are representing
Respondent.
Requesting times?
Yes, ma'am. Next week.
A. Ramakrishna Reddy Garu is also there. At request of the council for the respondent posted to 30 30 11. If 57, 1 minute. 57 in the morning, Katta Lakshmi Prasad Garu has appeared. Now he stated to dispose of on merit section. 57, item number 57. In the morning he stated, no, file ivandi. He said, please verify the file and dispose of. Issue fresh notice to apply for correct address. Recording, no? Recording, no?
See, 8.
ఇది పాస్వర్డ్ చేయండి, తర్వాత చూద్దాం. రాసి ఉంచాను కౌన్సిల్. నెక్స్ట్.
Case of picture, claim made for 8 lakhs, awarded 5 lakhs, paid in within 5 lakhs. Include cleaner 22 years in. Computation was done, below me. Scheduled engineering, 60% disability as per scheduled engineering. But loss of earning 100%. Why? He is unable to walk, even he is unable to walk, he is unable to sit. He even day-to-day activities also will not done well. That's why 100% loss of earning capacity. Both will have taken 60% loss of earning as scheduled engineering. But his skill level, cleaner, he become a driver in future. Loss of earning 100% has to be taken back. That is the only problem. And interest also available. Scheduled engineering. Accommodation as per calculation, phase 9 with that. But in the case of the 4,390, compensation 60%, 500.
Then why it has mentioned loss of earning capacity of the applicant at 100%?
60 by 100. Instead of 100, taking 60%.
The fourth one, loss of earning capacity of the applicant is 100%. Why it is mentioned?
Mentioned but not awarded.
Sir, we'll calculate. Sir, calculate change 4393.25. 4393.25 into 6 by 100, 60 by 100 into 221.37. సెల్ ఫోన్ లో చేయండి మంచిగా ఇవన్నీ కట్టలేదు సెల్ ఫోన్ లో చేయండి Four three nine 3.25 into 60/100 into 221/221.37. ఎంత వచ్చింది బిల్ సెల్ ఫోన్ తీయండి అది తప్పులు చేస్తుంది ఎందుకంటే ఇది 100% లేకుండా ఇది రాదు ఇంత అమౌంట్ అంతా బయట కరెక్ట్ 100% లేకుండా ఓకే బిజీ తీసుకో ఓకే నెక్స్ట్
Yes.
How many adjournments? Adjournments. Yes, sir. Endowments to do. No representation either side and call. Hence prostrate to fight from. All are connected, huh? 241 of 17 even first.
Let me have it this first.
I can't get your mark.
Snap goes into 21st election.
This one 60, huh? 60. Okay. 60, 21, 61 PM. 255 of 2017.
Thank you for very case of the on 10/3/2011 was traveling from Benapelli to Kapan. With the Chennai ticket, captain and forest of the station. Ticket is also there, ticket cap. Airport awarded only 50,000. Enhancement of compensation is only for enhancement of compensation.
Okay. What are the injuries?
Fracture there are criteria. Experiment to para 10 of the same. The applicant said to have certain fracture of hip as per exhibit A4 outpatient or issued by Nizam Institute of Mental Sciences. Usually the applicant body trauma fracture of pocket range, fracture of background, blood circulation of down. None of these injuries are issued injuries that will be and our heart filing report. The make rated the figure for chief compliance to bed. Vector providing the operation for office of the admin that the applicant has about its two facts are not taken summary. I think that proper to award an amount. According to the scheduled duty. No competition is 1,50,000. Make a 50,000 is every year. 25,000.
Yes.
Yes. Yes, as per the DRM report, he was a bona fide passenger, but as per the medical bills are concerned, he filed only outpatient part. He has not filed any medical bills and also the X-ray reports.
And they're not scheduled injuries.
Yes.
Admittedly, but for unscheduled injuries also, as per the act, they're entitled for compensation of rupees 1,60,000.
I like to know.
Right. Appeal is partly under. 1,60,000 is up. Next.
It's down four things. All the
Hmm.
four things to become late was problem. Express. It is not possible to be therefore get on. Because we do what in that the depends on the ticket. That's all your ticket from your ticket. However, both that public benefits either based on the law. What is that family perfect to sit with the applicant decide on call and issue of approved after meeting. As for an issue of approved government is bargaining to find out that the form that some of the second legislative file that as per the court of and that body taken for 30 years was formed. The federal power was taken and monitor from the state. It was for the set that recording kept like that exactly moment ever a fight from here. As the HFP really several bit by a part further failure, there are no getting the fight from the so we never from packets. It was not a on complaint. And following up the fight. Briefly, but it's better there was a white paper in which there are some links and the number available and also photo on printer sharing which feedback. Based on the fund, the report of several great kind of part of the part of the part of the that trigger to do after our basic report to construction to the rest of point of the so the exam that wanted to the back the segment from the towards the other on the what the requirement of the and market on one and on get a market production and the after the market of the standard that is not on airport, it can be for before the detail. However, real options of ticket which a Hindu or did not take to the claim that he was a former the share burden of payment which can be discharged by right in apartment of the relevant fact burden it gets set on the dividend and the issue can be decided on that shown on the applicant that comes after. It will have to be dealt with some place to get on the that form. Legal permission is particular case, we have filed the affidavit of the one, after then it was produced only document, material document, but reveal that the applicant and the fallen down of the case. Remember that approval is all from our attained by the part of The lordship is required to again, we could not
Inquest, who are the persons attended the inquest? Okay. 5, 6. Inquest లేనా? Okay. Record లేనా? Tuesday na? Tuesday. I'll put it as part 2. వద్దా? Tuesday వేద్దాం చూద్దాం. 14/11. 14/11 on that day. Okay. 21/11.
I'm ready, my lords. Morning, I was informed that they're taking time. They're not available.
They are representing respondent. No representation for the appellant.
Your Lordship, petitioner, Your Lordship.
Mm.
Your Lordship, I'm representing NS Geeta Madhuri, Your Lordship. My
Mm.
senior has got the file today itself, and we are yet to file the wakalat also, Your Lordship.
Okay.
Eh,
Okay.
Kindly have after 2 weeks, Your Lordship.
They have to serve me the paper or something. The points in the lordship might post it after in December.
6/11. 6/12. 6/12.
So
Much obliged, Your Lordship.
people will take on the 2 months. I think. Yeah, that's fine.
What happened? We are not having the file with you, and the other side counsel is available now. Every time, Bang.
By post before cutting, share to solar. Why people are traveling to the train. I think we find out that the train and material are dying. So after then we get to do. If I take to J1 to element AW1 and AW2, congress respondent not determine value that defined that A1 way fire. Main dead bodies from plants. I think they take us up to message was given equal to message was given certain patient superintendent to the railway. ERP and as well as RPM. Page number 2, page number 3, and they have given message to GRP and as well as RPM. Page number 4 which explains the first before. First before serial number 3 is PPP Satyanarayana RPM Venkanishka. They have given message to the RPF and GRP and RCF Venkanishka for that. Kindly take page number 6. Part 9. Due to 85 of Udar camping Yojana, Udar and Virisapa Mukhya and Parliament development on a border Tabak Dharma they will put for all the 75 for then maybe this operator command of a but command of a secretary very cheap. Order number 59 will complete page number 798. And that the action shall be followed from the unknown trade. Therefore, we will work on a course. Right, identity. Page number 19 will include the file. Father, page number 20, last paragraph. The fact and evidence collected during the course of investigation is established that this technique will take for doing paperwork in company and follow and one will grab the wife of the three considered the mother of the for separate from illegal further event to all of it get the parent house. It is job to create to consider to mother about 4 days that today on 25/4/2024 about the city that's how to proceed to follow and to attend what but some of the wife mother and brother further the city of an unknown trip and the result of the suspect pattern is on the spot kilometer number 1 from the this another report of R&D presentation. Patient will be family number 5. AW1 equal white. Rocket Jefferson. The one which by about children I have not felt that That's possible. 24/4, 2000, law, change payment out. All the 430 started from out to consider verification, the purchase ticket in the present, the part of ticket is for part of the platform number 2 is for the it can be the door on possible for some purpose and then part information about the same. It's down there, the and also regarded the statement. That's not on the way. It's about this. It belongs to the school for not one of it, but on body. Not change. Nothing not there. Average incident occurred on 25/4/2013. We concluded the investigation on 25/10/2013. Case number 37. Case number 37. They should conduct a paid inquiry to examine the relative of the determined only the rating local pilot or 50 SS and on this team out. They have examined only 4 parts. They have not examined. Page number 35, page number 35, page number 35. Letter number 39 before 30. On the filing the claim fiction, the letter was issued by the railway station to conduct an inquiry by the army. According to manner of investigation, they should commence the investigation immediately and complete the investigation immediately. All these cases during pregnancy of the trial court, they are conducting the investigation. When the matter is reached by the trial court, they should conduct an inquiry. And they are conducting an inquiry with the aim and object that the contents mentioned in the claim fiction is wrong. The aim and object that content mentioned in the claim fiction is wrong. ERP, two investigating authorities are conducting investigation. ERP is conducting investigation to know whether it is an accidental death or homicide. In manner of investigation, it is the mountain duty of the mandate to conduct a detailed inquiry how the passenger started from this house, whether it subject to any attack, how he fell down, how the accident occurred. They conduct a detailed inquiry. all these cases, they are conducting a simple inquiry with a name and object to that. Saying that they should conduct according to manner of investigation, they should conduct the FIR, expression, what everybody says. But they are simply saying that there is no authenticity of wallet from the pen, and if it is not there, then it's not a factor. In this case also, we have not examined the family member. It is not a fair inquiry. But at page number 39, saying that there is no authentic record on the above inquiry, it is clear that there is no authentic record or evidence that the victim traveled by train and there is no definition to consider in the bona fide document. Decision is not clear. Effect is conducted in the presence of RPF connected. PRM report on behalf of PRM, RPF has conducted the inquiry. RPF head constable said that he accidentally fallen down from the train. In conclusion, they are saying that there is no authentic evidence that he is not fallen down from the train. That shows that they have not conducted a train investigation. If it is not there, and it's a training of 58. It's on and mark of PRM. Form number 1. Saying that it is an accidental fall, accidental fall. They are admitting that this is an accidental fallen down from the train. One side they are saying that accidental fallen down, another side there is no authentic evidence. And the condition of the third, it is better. That is to the other is already before. Here also the payment is such of within negative claim that was qualified the initial burden thinking of the claimant which can be discharged by finding an operation of the development. Burden to the set of the value of the value and the issue can be decided on of this attending circumstance. Particular piece, payment data to do data to one, all the for final report of the data the absent of the final of the train. Already there is no evidence on behalf of the right, on behalf of the railway. In transaction of the land for the respondent driver, supervisor within the knowledge of the defects of the right, and then instantly the applicant have filed affidavit of rate of the bond to along with the document evidence the form of rate of the they want to they have discharged their initial burden. Accordingly, the burden takes on to the respondent driver to establish whether the receipt was not a bona fide plastic. The respondent got marketing, can so whether publisher statement of only if some information provided by the board if I find out so that obviously the board there. Here to start the decision for not providing it cannot be that the decision is not nice or what your loss is fine. Okay. Import so judgment. That's the problem. And part of the payment of the fee. The number of cases, very long number of cases, finally, page number 17, post that. Either prove that here presence of failure to regulate not completely over the exclude of three votes on the public complex. However, here options are ticket if the schedule or not negative, the case that because the moment the actual burden will be on the expenditure that is the price of.
Yes, counsel. Yes. Yes.
Kindly see the judgment of the court of the tribunal. In issue number 2, no, for paragraph 12. Paragraph 12, after considering section 124A, and in para number 13, lots after considering the Reena Devi case, lots of the tribunal, lots of dismiss the claim. Moreover, lots of the finding is lots of para number 16 is the finding. Once the applicants have filed the discharge, initial owners lying on them, question of burden proof shifting on the respondent to show that this is was not a bona fide person that does not arrest. The applicant has to file any proof of accident fall of the disease. Admittedly, lots of they have not filed any ticket, lots of no eyewitness was examined. Only the interested witnesses, lots of wife and the brother was examined. And one more fact, lots of in the evidence of AW1 also for page number 23.
Yes.
There are number 4 ones. I submit that on so early morning, my deceased husband left the house informing me that he was going to Godalkani by Bhagyanagar passenger train. I submit my brother Javed went to railway station to set up my deceased husband. I came to know that by purchasing the journey ticket from traveling from Mancherial to Ramagunam, my deceased husband boarded Bhagyanagar passenger train. I came to know that there was heavy rush on the day. My brother Javed was with my deceased husband till the train left station. Submit that on at about 7 a.m. My neighbors received a phone call from railway police, and it was informed that my deceased husband died by falling down from the running train. Immediately, myself and others rushed to the police place of incident and identified dead body. I submit the police inquired us to our statements. I submit. I came to know that on 25/4/2013, my deceased husband while traveling from Mancherial to Ramagunam in Telangana Express. Once they are saying lots of in Bhaginagar, here they are saying in lots of Telangana Express. There are contradictory lots of in the deposition of AW1 and also lots of in the AW2 also the same. He lots of he stated he was there while he was the deceased lots of boarding the train. And what he was saying, he boarded in Bhagyanagar train and fallen down from Telangana. There are contradictions also by the applicants itself. And in the Reena Devi judgment also lots of the tribunal also extracted. One more judgment also. Even as per that judgment, lots of the rain ticket is necessary and the claimants or the applicants have to prove that the disease is bona fide pathogen.
they themselves also not proved that. With regard to the inquiry logic, they have never challenged the fact logic in that tribunal court below. Now they are raising this logic in the appeal. Their case is not like about the investigation by the railway authority.
Just one example to get that bargain over express. Right. 71. We do not understand. That's the reason I was I will take an adjournment to the morning, but that is the only active.
Not for item 70, I'm seeking adjournment.
I inquired with the other side also.
Okay. Oh.
You told not.
No. Actually, what happened is we started verifying the trail court records, wherein the case has been already disposed of and nothing remains, nothing survives. Those kind of cases has been listed. Yesterday I have discussed now. So they made it like specially identified cases. So nothing survives in these cases. 70, 71, 72, 73.
Yes, the same, but the PCI Act.
I don't know. It's not the all. Our people has verified online.
It is on the employment form of this.
Maybe they are disposed of. This is disposed of suspension. This is coefficient and item number 10097. This is item number 70, I think. 70.
PCI Act for file.
ಅದೆಂತ ಐಟಮ್
ಸ್ವಲ್ಪ ಪೆಂಡಿಂಗ್ ಇದೆ.
తప్పు పడిందా నెంబరు నెంబర్ తప్పు వచ్చింది because we wanted to clear up all these cases. They are unnecessarily being listed. Important cases are not getting listed and these cases have been listed and now no one is appearing. Yes.
70.
Yes, item number 70.
The councils are filling my lord.
That is okay. Have you, please tell me the stage of the suit.
And the prox council, my lord, even the council wants 2 weeks time to.
See, that is the reason. These cases, so nothing survives in these kind of cases.
To ascertain the fact.
We have already taken online. We have the list with us. See, these cases have been getting listed unnecessarily and important cases are not getting listed and council are requesting every time they're mentioning and every time we are giving directions to the registry, but those cases are not getting listed.
I should get instructions regarding this. Blood item.
So please, you also kindly verify and inform me because we have seen online. That is the online list. See, when nothing survives, why these cases has to be listed? Unnecessarily, it is a waste of time.
Yes.
Yes.
But item 72, madam.
The same thing for you also. Please verify.
We will verify.
Verify. See, when nothing survives, we'll dismiss all these cases. Sir, 74 also, sir. Why we have done this exercise? For adjournment or what? I'll do one thing. All these cases, I'll post it on Tuesday. Tuesday, please inform me. Then we can remove all this.
My matter name is.
Don't worry. From 70 to 74, we'll adjourn to.
Maybe taken next week, no, for that I will take it. Any other petition was filed for restoration or it could not 74. Only next week.
I'll post all the matters on 16. Next week, 16. Yes, item number 65, Chandrasekhar Garu, only short time is there. No, we'll adjourn. About 2:30. You can't get him again. He's not appearing now on Mangulal. At 2:30? 2:30. Is any other?
Item 66, Millard.
66. You're ready with the opposition?
Ready, Millard. Last occasion, this guy, Honorable Court directed to get the record, call for the records. The records are.
Records we have received. Who is the other?
Yes, Lordship, this man. The others, this matter may be taken on next week. Next week, Millard, I am also preparing the booklet, Millard, along with citations.
Both councillors present, 66. Both councillors present. At request of the council, posted to 24.
Next week, we will launch it then.
Yeah, 24/11.
67 also.
19 matter. Is there any urgency?
Yes.
17/11. Yes. BV Rao.
67.
Ah,
67, my lord.
You are representing?
But I am appellant, my lord.
Hmm.
But in this matter also, this honorable court was pleased to call for the record from trial court.
Record it, 67. We have not received the record, sir.
And in which case, my lord, you'll actually kindly list it in first week of December, my lord. In the meantime, we'll prepare.
Pradeep Reddy Garu, who is there? Okay. Counsel for the respondents, the counsel for the appellant appeared through virtual. About LC records, he has posted to. Records has to come from Mitchell Malpaskiri. Posted to 30. Next.
60. My lord, I am for appellant.
Yes.
I am for appellant. Deposit process, my lord.
Your senior.
Person.
Yes.
I am for appellant, my lord.
Yes.
I have sent a personal notice to the respondent as per the orders of the honorable court.
You have already filed memo. You have already filed memo. Memo is there. Yes.
Yes, your lordship.
Notice is served or not?
Tracking report has to be filed, your lordship.
We will verify, sir. We'll verify and then adjourn.
My lord.
Yes.
From 69.
Item 25 is already adjourned. Someone represented, he is going to file wakalat. He's going to file wakalat. Already adjourned to 6/12.
Item 69, Millard. And for the respondent plaintiff, Millard. Last occasion, I filed a counter, Millard.
Counter in?
It is
ISR pending in 69. 69, no ISR pending.
no, yes, Millard. I was yellow. I had to be filed the counters, Millard.
You have to file counters in what?
For vacating of the interim orders.
Vacating, it is a petition only, not counted.
Yep.
Vacate petition, okay. So you're requesting time, you're representing the appellant, huh?
Respondents, Millard.
Respondents.
Yes.
Okay. At request of the counsel for the respondent posted to. It is 23 matter, I'll adjourn to December 7/12.
Place.
Item number 33. Morning, I could not.
Sir, all those matters are adjourned already. 33. 33 is adjourned to 6/12. Enhancement of rent for the subsequent each slab for 3 years subsequent to the first slab from 1193 to 31/12/95 from 20% to 15% as indicated above while maintaining the order in all other respects. With regard to the interest on the arrears, as there was no finding by the trial court in this regard, the arrears shall carry interest at 6% per annum till its realization. No orders to cost.
Oblige, my lord.
Utkaranta, same. Civil written petition disposed of by reducing the enhancement of rent for the subsequent each slab of 3 years subsequent to the first slab from 18 to 94 to 17 to 97 from 20% to 15% as indicated above while maintaining the order in all other respects. With regard to the interest on the arrears, as there was no finding by the trial court in this regard, the arrears shall carry interest at the rate of 6% per annum till its realization. No orders to cost.
Lord, it should be partly allowed, no, my lord. Oblige.
Password matters. 230. 230 కి ఏమని చెప్పాను 230 matters ఏమన్నా
Item number 35 was passed over at 2:30.
Item number 35.
35.
Yes. See, council is waiting since morning. Yes, what do you say, council?
Yeah, I say that it will take only 5 minutes. I am addressing the court, then he can join if he is at 3.
See, if I complete my list, what to do?
I'm sorry, madam.
See, this is also court. And furthermore, your junior has requested time at 2:30 so that I have posted the matter at 2:30 only because other side council is at Delhi. He's not in Hyderabad also.
I know the difficulty, madam. Sorry for court, madam.
This is not the first time. They have taken more than 20 adjournment.
Okay, you proceed. You proceed. And
Yes,
your junior will note down. You proceed. Then what to do? How many times the case has to be adjourned? Every time he's coming all the way from Delhi. Every time. And today, on my request only, he has came online because he's traveling. I said you can utilize the virtual mode, so he came online. He's using the hybrid mode. And now your junior asked for 2:30. I have posted 2:30, and now you say at 3 o'clock.
Receipt may continue. They have taken more than 10 adjournments, more than 20 passovers. No further any liberty can be given. They are misusing the liberty given by this honorable court.
See, I'm accommodating you every time. You should understand that also.
This is the
Though
fact
he's
of the
coming
case.
all the way, he's insisting, but still I'm accommodating you only.
10 minutes, madam.
Okay, go and come. Go and come.
Let's see.
This next matter. Yes, 10 minutes. After 10 minutes, the council will be in the court, it seems. Yes, next. Password matters.
Let's see. After 10 minutes, it will be taken.
Yes, sir. After 10 minutes, he will come, it seems.
Okay. Thank you, ladies.
You are representing 478, item 37. Yes. Content delay. What happened to the notices? Court officer, please verify and tell. Proof of service filed. Your proof of service is filed. Okay. How many days delay? 7 days. Okay. Okay, come. We'll order this. I have one of 2018. 1 minute, let me verify the address. Chandra. So address. Is the sixth respondent is the LR? Who is sixth respondent? This CH Chandra Reddy. No. The notice has been sent to Chandra Reddy. He is not the party in the main. Is not the party in the main suit. In the main suit. In the main suit, he is R6. Same address. Okay. It is deemed service only. Okay. Yes. I can't hear you. Use the mic. Speak loudly. Be clear what you want. You file an injunction petition. See, other side, respondents have received the notice. They have not appeared. Okay. Why don't you get ready in the main appeal? Huh? IA 1 of 2019, 7 days delays condoned. IA is ordered. 1. What is the main suit is filed for? Suit for partition. Posted. I'll put it for short date. You get ready. 2311. It's 43. Yes.
Don't delay. Yes.
Is filed by the?
Filed by the appellant.
Okay. Okay. How many days delay?
5,000.
5,737 days in filing the appeal. Why that huge delay?
My lands are taken away by land acquisition proceedings in year 2006. For that, only exchange of land acquisition proceedings. Demarcation also gone. Everything is over. Suddenly they find 411. Telling that I filed petition in 2006. And interim order was granted not to dispose them and let the proceedings has to go on. While the petition is pending, they passed an award for the amount of 7 lakhs. Total 37 acres. Total amount is 7 lakhs was granted. We denied that. Then the reference to the district court. OPS. The OPS confirmed the award. In that in the award also, contested the matter. The evidence also not recorded. Earlier proceedings, 1995 proceedings, exchange of land proceedings. not marked. The evidence was not there. We filed the petition also. The evidence was not done.
You're the counsel for the respondent in IA. Have you filed counter? It is 5,737 days delay, and you don't want to file a counter. We are going to file counter.
And the second question has to comment on the logics because they are appointed.
His name also printed.
Second respondent is L. Prabhakar Reddy garu. GP for appearance is respondent number 1. Respondent number 1.
The lands are taken away. They all sold out the bed companies. We are not receiving a single anything. It's the bed company.
At request of both counsel are present, at request of the counsel for the respondents for filing counter in IA 1 of 2023 posted to 4th December. Item 40 అయిపోయిందా? What happened to item 40? Look at them. అది అడ్జర్న్ చేద్దాం. అడ్జర్న్ చేద్దాం. Posted to 20. If you are ready, counsel, if you are ready, then tell me. No, that counsel. You said 10 minutes. No? You said you'll go to other court?
No, for me, my lord.
You are not the senior counsel. Wait, please wait. Your senior is going to come. I thought he's the senior counsel and why he is asking time. Anyway, I thought you are going to other court and after 10 minutes you wanted to return back. For that reason, I said you can go and come back. Okay, well, no problem.
Yeah, yes, ladies, you can wait.
I know. Because every time this counsel is ready and has already submitted her argument 3 or 4 times.
We are also reading.
That is the reason. Yes, Chandrasekhar garu. Yes.
Section 152 of 2014 for business from Indian Foreign Stock Exchange. Foreign stock, father and mother of the. Down to the two combinations. Yeah. Speaking of the GM for protected 2014. Homogeneous subject development under. To attend the meeting. Specific what you want folks, within the method of development. With round of overall advocate. So I was not ready to come to develop and talking from development to development. On specific point to not 40, while traveling from development to development after start to get trained. Fill up the way, that's the current talent now and that is not the next morning. Also, also, already the checkpoint. After 4 days, it came to the parents. Parents repeatedly try to contact his son through phone. Suddenly one day, one police constable detected this phone. The police constable had presented his phone, but son that was the next step. The photo and the identified photo. This is the actually. Anything is because the side they want to remain and unit one and data to two of for exam. On behalf of railways, nobody was they want to A9 marks on behalf on our behalf, it to one and AW two of then nobody was examined of the basis, and which is the document number one. Yes, they want to pay. I pay a CMA 220.
CMA 222 of 2019.
I picked the wrong bundle of there was tomorrow.
You want to go through the file now?
Well,
Or else I can adjourn also. It's up to you.
there was also tomorrow or Tuesday.
Okay, Tuesday then. Both counsel are present. At request of the counsel for the respondent positive test. 15 minutes.
Look 68. See, one people ready.
No representation of the appellant on call. Hence posted to 2023. 8th December. ఒకసారి కూడా పిల్లండి స్పెషల్లీ ఐడెంటిఫైడ్ కేసెస్
Especially they found the 70
నెక్స్ట్ 75 to 83. Passwords again. No, you do one thing. You brief the case, facts. He has already completed 3-4 times. Every time, though you are not getting ready, the counsel for respondent every time has submitting his arguments. In the meantime, you can brief the facts. Mm. Okay. And after he completes, your senior may give reply. The reply arguments he can again.
May I continue?
No, let them see the. This is their appeal.
Yeah. Sure.
Item entry 30.
5.
Despite the insolvency, the petition not support occupation or complete tribunal matter and get filed for Hungary. The petition matter was severe consequences of insolvency when the petition is admitted, the company will be taken over. Instead of the first one to give a company the finding of protection, the company will be taken over by potential profession. There severe consequences. The entire case of the respondent matter before the Honorable NCLT was that the petitioner had to pay money. We had to, even before subscribe to the filing of the company petition, demand this of issue matter, the demand to get it. It's now 120 ton of KRP matter. I have 120 ton KRP paper.
Yes.
Matter. The 120 ton is 30/20/19 minor the date for the demand. Where they say that they have to get 2 crores 7 lakhs. And page number 128, my lord, serial number 1, total amount of debt. Now, my lord, page number 135, my lord. Serial number 7 is a list of documents attached to the application in order to prove the existence of operational debt. There are, my lord, 4 documents. Copies of purchase order, copies of invoice, copy of acknowledgement of 2011, calculation date of 2019. First document, my lord, 2012. Second document is 2012. All the documents 2012. My lord, sir, in 2019, he is filing for documents which are of 2012. My lord, sir, under Article 135 of the Limitation Act, the limitation period is 3 years, which is what we have taken as the reply. My lord, sir, take a reply, my lord. It's the page number 165. At page number 165, the reply dated 21st May 2019. Page 165. Paragraph 3. We further state an admitted position that the amount can be demanded under IB required to be a legally enforceable debt. However, the amount is included neither legally enforceable debt nor the justifiable debt, and it is not an operational debt. The notice of the response is totally instancy, malafide, and suffers from laches. Now, my lord, it's paragraph number 6, my lord. I'm explaining this, my lord, because it demonstrates the content of the party. In fact, the present demand notice issued by the progressively part by invitation at the last date of payment made by 27 by 2015. 27 by 2015, 2019, 4 years now, beyond Article 137. And the same is reflected in the statement of account provided by the downward demand notice. You would like to bring to your attention that the law of limitations are applicable to the property edition and the IPC 2016 by virtue of recent judgment passed by Honorable Supreme Court. The second principle of law minus the limitation act applicable to insolvency panel. Now, after the demand is issued, they find the company petition. Take up the company petition. My lord, it's page number 26. Start at page number 26. In this mind, I like page number 26. The relevant page number is 45. Where one more table.
Now, first, we have said so in the demand notice, it's like the demand notice progressively barred by limitation. They introduce a new document, my lord, which is at page number 122 of CRP, my lord. I have to take a 122, my lord. Look at the document, my lord. I also be aware of the fraud being played on the petitioner by the respondent in the tribunal. This they take the legend statement. The document is not clear. This is how they are filed in the court, in the tribunal. The document. 123 is the clear document, full copy filed by them. They say this document extends the limitation, my lord. That is at page 43. My lord, that's in the document. The document is not clear. They say there's some stamp of granting infrastructure, employee name is not mentioned. At page 43, my lord, of the CRP. For the first time, my lord, when filing the petition, they say the corporate debtor has specifically admitted that as of 14 April 2017, an amount of 26,79 crore is due and payable to the operational credit by the corporate debtor. However, till date, the corporate debtor has not been unpaid operational debt. This was not in the demand notice. Immediately coming to know of this document, my lord, we got to know of this document. We filed a criminal complaint, my lord, because we know the document is not filed by us. We are not aware of this document at all. It's a post document. Therefore, immediately, my lord, we have filed a criminal complaint, which is at page number 19 of TR. We have 21 of CRP. I'll read the criminal statement, criminal complaint, to show the bona fide of the petitioner. Because, what has happened, if you look at it, on 13/5/2019, a demand notice issued to her. There was no mention of the letter statement. On 21 May 2019, they replied. Then in August 2019 is when the company petition was filed. Immediately September, 3rd of September, we got the petition in August. We saw the document. We verified it directly. No one signed this document. It was not our document. We filed a criminal complaint, which is at page number 22 now. I'll read the complaint. RIA has issued date of the purchase order for I construction equipment which is the respondent category of supporting material, strategic material, and other purchase order. The items are filed application 9 before NCA, it gets giving an amount also into for copy of the petition amount for supporting documents is filed here. However, I reach a level petition that is still an amount of 1,46,29,000 RIA against the total debt you have mentioned parameter here. Such statements are contrary to the above. And the same petition, therefore, can see that the petition financial need to see the complaint carefully and in the beginning then fraud. If you are showing any act not achieve its fraudulent case, here another is the operative portion. I reach a filed a forged and fabricated HS statement before the NCA. To be signed and stamped by an unknown, unrecognized employee of RIA 14/4/2017. We got to know in August, September, we filed a complaint. Such ledger statement discloses an outstanding and owing 68 crore payable by RIA to RIA and basing upon such post ledger. I just claimed before the NCIT that amount mentioned in the ledger is operational debt due to paper by a copy of the forged and fabricated ledger allegedly signed and stamped by the employer of RIL on 14/4/2013, present at page number 92 and here 2. Now, RIL submits the petitioner that the alleged ledger filed before the NCIT is forged and fabricated by RIL and under the signature, now the official seal fixed on the alleged ledger belongs to RIL's authorized signatory, and such document was forged by RIL and executive management officials with the sole intent to wrongfully save their claim for pleading on the ground of limitation and to bring their claim within the purview of limitation act. I reach an executive management officials a full understanding of the fact that they should not have raised their case presently Waiting upon the purchase order, as the same were issued in the year 2012, and the limitation period to file claims on such purchase order would have ended in 2015. Hence, High Reach and Executive Management have filed the forged and fabricated document, allegedly signed and stamped by an undisclosed employee of RIL 14/4/2017, and in order to get the sheet of right, they have filed for NCLT. This complaint was filed after filing of the complaint. The document was filed for Honorable NCLT. Xerox copy. Therefore, my also filing the application under which the issue order has been passed. Now, my document take up the application. Right, my application is the page number 14. An application filed on behalf of corporate debtor, which is the petition there, and the section of insolvency and bankruptcy code. That this page should be on the 65 million.
Insolvency and bankruptcy. Insolvency.
This copy is better. Let's see. Any person initiate the insolvency resolution process or liquidation proceeding, fraudulently or malicious intent for any purpose other than for the resolution of insolvency or liquidation at the case meeting, the adjudicating authority will impose upon such person a penalty which shall not be less than 1 lakh rupees, but will exceed to 1 crore rupees. If any practice by 1 man is the relevant law. But the reason why such a drastic provision is made is because the consequences which follow after this petition, which will be a section 7, section 14. This petition was filed in section 9 of insolvency bankruptcy code. When operation created for purported dues minor. Now, if the petition admitted the consequences of section 14 minor, as the section 14 minor, the reason why I want to read section 14 is to explain the drastic consequences which will follow of malicious prosecution. Section 13 minor, section 13 minor to stop the admission. Section 13 of IDP. The adjudicating authority, after the admission of application of section 7 or section 9, present between section 9 before NPLT shall declare a moratorium of purpose referred to in section 14, cause a announcement for initiation of corporate insolvency resolution process. Process call for the submission of claim under section 50, appoint an interim presidential professional section 60. Then for section 2 minor, the public announcement refers to clause of section 1 shall be made immediately after the appointment of interim presidential. Now, my lord, the reason why what would happen when it is admitted, a particular person, professional for insolvency prevention process is admitted, he takes over the entire company. The entire company, the public listed company, will be taken over by this particular person, a third party, and then my lord, he will run the company, my lord, and for the period of 2 years, he affected after IPO. Now, my lord, we get for more. At section 14, what happens with it when IDP is detected? Subject to the provision of section 20 on the insolvency commitment date, the adjudicating authority shall mandatory for the order. The NCA by order declare moratorium for prohibiting all of the following, namely the initiation of suit or continuation of suit. Again, the corporate data including decree or order in any court of law, tribunal, arbitration panel or authorities, transferring encompassing agency or disposing by the corporate data any of the or legal right or beneficial interest therein, any action to foreclose, recover, or impose any security interest created by the corporate data in respect of the property, including any action under the Act, he minus the recovery of any property by an owner or lessor with the property occupied by a person of the corporate data. Because of the grave implication minus of this proceeding, if I confer specific power on NCLT to inquire whether there is malicious initiation or not. Under that provision, let me rule 131 of NCLT rules, the present application of file matter for NCLT rules.
Yes, yes. It's okay, sir. Other side council is insisting continuously for the last few days or month.
I'll just continue from there. Because of this serious application of the company management, etc., everything is there. Malicious initiation.
Mm.
When somebody initiates maliciously, accidentally, take action.
Mm.
That is but should have it. That's it.
Just a minute. ఇంకిచ్చేసేయండి
For your
insolvency and back to tax.
fraudulent or malicious initiation is prohibited. Any person initiates the insolvency of this process, fraudulently or with malicious intent for any purpose other than for the resolution of the insolvency or liquidation, as the case may be, the adjudication of party may go upon such person of penalty which shall not be less than 1 lakh per day. But this is in addition to dismissal of the case, but they have to impose penalties and maliciously fraudulently. The proceedings are summary in nature. There is no trial. But it's based on documents only. Therefore, my lord, the provision itself provides for production of documents if asked for. And that is what the one. I just copy that whenever I have something told. But the petitioner, in the CIR proceeding, that is the respondent here, find a document which is called a ledger sheet. Not just to see that ledger sheet, which is at page 120. Where it will be completely illegible. Almost
Just now we have seen, yes.
that is the one which he files, a copy of which he files in the HCA. And he claims the next page is a neat type copy of it. So, my lord, this document at page 122, he claims that there is a signature of my representative at the bottom. Not just you see into the landscape page, in the middle, although it is not readable very clearly. Somewhere where it says for Ramki infrastructure bracket Ramki group, there is signature. The bottom, in the middle of the page bottom. So this is a forged document filed by my learned friends. Copy of this document was never given by me. We do not mention whether this proof in this manner. And this is a clear case of forged document being filed. And the reason why this gentleman has now filed a forged document is not just a note, he's filed a photocopy of a forged document before the court bill. The reason why he is filing this is that all his claims are 13, 14, 14, etc. That period, claims also. So, but clearly on the face of it on paper itself, it is barred by limitation. Under IBC proceedings also, section 230, limitation law applies.
3 years only.
He knows very clearly.
Is it 3 years only?
3 years.
Okay.
Same law applies. Limitation law.
Okay.
So, when he knows very clearly his claim is barred by limitation. When he issues the notice before filing this case, the statute requires a notice to be issued to me. He does not mention anything about this document. He simply says his invoices of service. In my reply notice, I say it is incorrect. In any case, even as per your admitted case, you are claiming amounts of 2014, etc. They're all barred by hopelessly barred by limitation. I reply like, but in order to get over this reply for the first time in a petition, he comes up with a photocopy of this forged document as if this is an admission of crime. So now what do? I have no other method. So now I file an application saying This is a forged document. According to me, I have never paid this. Please direct him to produce the original of this document. The reason why original is needed is forgery can only be decided on an original document, even my criminal law. It cannot be decided on a photo. That is the law. So NCLT has the power to summon any document filed by any party. He has chosen to file a photocopy of this document. I file an application to the NCLT to say direct them to produce this document. Under Regulation 100, Rule 131. I will just quickly read for it off. These are called National Company Law Federal Rules 2016. In this, page 82, Rule 131. Bottom of the page. So page number Rule 131.
Yes.
Application for production of documents, form of summons, except otherwise provided hereunder, discovery of production and return of documents shall be regulated by the provisions of CPC. An application for summons to produce documents shall be a plain paper setting out the document, the production of which is sought, the relevancy of the document, and in case the production of a certified copy would serve the purpose, whether the application is proper. Now, therefore, the power is there for the NCLT to direct under 3. Summons for production of documents in the custody of public officer. Now, that is for the public officer shall be addressed to the concerned deputy clerk. But now, CPC provisions are for production of documents. CPC, the court has the power to command the parties who has filed the to produce the original. That is all, my lord. I am saying that I know for a fact that I have never given this document. This gentleman seems to have created a document in his office as an afterthought because in my reply notice, I specifically said it as part of an application. He does not mention this document. What is very as an afterthought, he creates it, files a photocopy. So, by filing photocopy, shielding himself from criminal prosecution of a forged document. But at the same time, he wants the court to rely on the photocopy of this forged document to admit me into CIR, take over my. Therefore, please direct him to produce this document with my application. Lordship may see the prayers in my application. It's there in the impute order at page 8. When impute order, I will read it. It makes it a very interesting reading. I asked for prayers X. Impute order says, as if I thought of ask prayer and rejects prayer. My prayer is something else. Impute order decides something. The present application.
Page number 8.
18.
Yes.
Therefore, non-exercise of jurisdiction. Squaring our 227 as to the maintainable. Now, this is the order dated 5/2/2020. Passed by the NCLT High Court. This court, honorable court would have the picture. Present application bearing highway is filed seeking following reliefs. Not just legal. Direct the operational operator to produce original copy of the ledger statement dated 14/4/2007. I am asking for original of impose penalty under section 65(1) for malicious initiation. Then dismiss the petition. Now, the facts that are mentioned are at para 3, same facts which are narrated to your lordship. That para A, I have said so that it is hopelessly barred by limitation. Para B, ledger of 14/4/2017 has never been issued by the applicant query, and that the seal of signature appended to the forged and fabricated ledger statement does not belong to the applicant or its authorized parties. Operational operator, after understanding the claim is hopelessly barred by limitation, manufactured the forged ledger statement to circumvent the provisions of Limitation Act 1963. The operational operator has not revealed the source of the ledger to which it is allegedly communicated by the operational data. The respondent forged ledger statement dated 14/4/2013 appears to have been created only after the applicant provided supply letter dated 21/5/2019 intimated that no legally enforceable debt exists in favor of the operational operator as the basis of the claim which is disputed is hopelessly barred by limitation.
that the applicant has filed a detailed criminal complaint in the police station, Raidurgam, on 3/9/2019, much before the present petition was even listed for hearing before this adjudicating authority. The station house office, Raidurgam Police Station, requested for the original copy of the alleged ledger statement dated 14/4/2017, along with directions from the adjudicating authority if any was released. In response, respondent does not say, I do not have the original. Respondent says they can produce their own ledger copy. They have given to you. That cannot be the ground. I'll write. If they specifically in their counter affidavit in the DA court below, they had said, I do not have the copy. They specifically say, I have the original, not copy. I have the original. But they don't. And I ask myself, any fair person who has the original, I ask myself, why would that party? This court all can see. Even here, they contest matter for 1.5 years, but they don't want to give this order. They know very well that they have forced. They don't want to take. That is the only. But 1 minute the case can be over there or here. I just producing the document. Anyway, I will show about that. That is just to show about the deliberate unafraid action on them. Now their counter about what they say is essentially that we can produce our ledger. We can print out another ledger copy and produce our internal ledger. No, that is not the basis. You have filed a document in court as if it is a real document. We are saying it is forged. Please produce the ledger. Now, Lordship may note No.7. After the contention, paragraph 6. Paragraph 5 says, heard both sides peruse the report. Paragraph 6. It is the case of the applicant with the ledger statement dated 14/2017 filed by the operational operator in the main sequence has never been issued by the corporate debtor. The seal and signature are forged and fabricated, and the same does not belong to the applicant or its authorizing agent. Whereas the operational operator responded herein has stated the same has been provided by the corporate debtor itself, and there is no requirement for providing its authenticity, and further stated 3 out of 5 purchase orders are the same. 3 out of 5 purchase order issued by the corporate debtor herein bear the stamp Kamki Group, which is claimed to be forged. The respondents herein are also contended that the copy of the issue statement was not served with the as the same is an additional document affirming extending guilt. It is well settled principle of law that the burden to prove the truth of an allegation. This is where things become very fine. Burden to prove the truth of an allegation is always on the person making the allegation, and he should adduce evidence to prove his case. However, in the instant case, applicant wants this adjudicating authority to direct respondent to furnish evidence to prove his allegation. I am not asking for any evidence to prove my allegation. I am asking the document which they are relying on. Further, this application cannot be decided unless question regarding authenticity of the included ledger statement is determined. Absolutely no meaningless. Application is to produce the document. I am not asking the NCLT to decide the authenticity of 14.4 before the production of the document. My application is please place the document in the court.
Understood.
Yeah. Once that order in the 130, they don't need whether it is authenticated or not. It is putting cart before the horse. After the document is produced, its authenticity will be checked. Before, I am asking for production of that. Now, Lordship will see next paragraph, 8, even worse. From the above, would question arising for consideration before this adjudicating authority place? Can this adjudicating authority determine whether the included document is forged or not? This is the issue that the adjudicating authority decides. My prayer is to produce the document. The prayer is something else. They think that prayer is this and pass an order of this case. But even that is incorrect, or because I'll also show that. With regard to the first stated question, the Honorable NCLAT in the matter of so and so has categorically this order very extremely absurd. I mean, it's the simplest word that I can use. Is because even in this case, this paragraph is not the issue. Of an NCLT, some stray observation that's picked up and put it down. Even if my case was to determine fraud case after production of the document, this would have been wrong. And then going further, actually it is not required because they have simply misled themselves and decided something else which I asked. to decide something. Now, let us read this, just a 2-page order. So that I can show that this was not issued. Then the appellate employee of ESC Limited as an operational creditor. An operational creditor will be a petitioner in the court. Whose application under Section 9 of Insolvency and Bankruptcy Code for registration of corporate insolvency registration against its employer ESC Limited. Operated, that is the respondent. The adjudicating authority, that is National Company Law Tribunal, Delhi, taking into consideration given facts that the applicant has filed his form for the TS with regard to the financial year. When the TDS was deposited by the consortium as of the previous financial year, when TDS was deposited by the respondent, rejected the application being with the learned counsel. The reason why it is not maintainable is mentioned. Learned counsel appearing on the ground for appearance of the legal sanity of the recent year is to claim that it is not having been taken forward. And the application under Section 9 from the application of Section 9 filed by the appellant, he finds that the appellant has shown particulars of the claim under following heads. Salary for period 14, December 14 to March 15, which is part valid. Reimbursement of amount financial year 14-15 as per SAP legislation, which is also part valid. Salary for the period August 2016 to March 2017 plus period. 3 years of subsequent period. Leave encashment for July 2013 to March 2007. However, the adjudicating authority noticed that the claims for the period April 2016 to March 2017 do not pertain to corporate debtor, that is debtor TSC Limited, but to Messrs. DSCL Pension One Consortium as stated by LSP Form 5. In view of such information, we observe that the application was filed by the appellant with intent to receive the use of the corporate debtor and not with intention for resolution of the liquidation. Therefore, we hold that the adjudicating authority rightly rejected the prayer of the appellant. But here it ends the decision that he claimed that X amount is due from a particular company called DSC. All the claims that he has made against DSC are barred by limitation. The claims which are made, which are not barred by limitation, are against company which is called DSCL, not this respondent. Therefore, rejection of Section 9 is correct. After having dealt with that, as an obitter, let they say one word, one line. So far as the question as to whether the documents are forged or not is concerned, it cannot be determined by the adjudicating authority, National Company Law Tribunal, or the separate tribunal, and therefore adjudicating authority rightly not deliberated on such issue. Completely obitter. The judgment ends here, and this is of a tribunal. But the provision itself provides if it is fraudulently given. But Section 65 has to be reviewed. Fraud and investigation will be done by the police. I have filed a writ petition to register the complaint. Restriction whether that writ petition was pending is to be examined. I have given the complaint to the police lordship team already in the June order itself is required. That the police was not interested in an FIR, I filed a petition. The writ petition document received dated 21/4/2020. WP number 2495/2009. But during the pendency of this petition, after the order was reserved, there was a Supreme Court order which came saying that directly requisition cannot be filed for the purpose of registering it. If complaint is not received, magistrate court only one. Higher official and then magistrate court one has to do. So after reserving, when the judgment was being written, the Supreme Court judgment came. So in terms of that Supreme Court judgment, whether this writ petition came to be dismissed, holding that complaint ought to have been registered by the FIR what to have been registered. However, in view of the Supreme Court judgment, I cannot direct the respondent to directly register the complaint. Party should go to the concerned official and or concerned court. Then I filed complaint before the concerned court. Now the concerned court on 16/10/2023 has passed an order to register the complaint. Order of 13 additional Metropolitan Magistrate at Rajendra Nagar, SR number 7116 of 2023, directing the police authorities to investigate about the allegation of creating false documents and file a report within 15/12/2023. Now, this is the additional material that has been filed before your lordship through an affidavit that happened on 16/10/2023. So, my lord, on the very same document, the Metropolitan Magistrate at Rajendra Nagar has directed the police to register the complaint, investigate and keep a record. Now, my lord, for that complaint also the original document. I am not asking, my lord, for adjudicating authority in my application is only to produce that is available under one. They completely, my lord, decide something else and do not decide the jurisdiction that they have to produce the document. Now, my lord, that is squarely covered under Article 257 in terms of supervision by this honorable court as the constitutional court over the tribunals within the state. And Article 227 of the Constitution under which this is filed, I'll only quickly read. In fact, I don't need to read, but it is the supervisory. The reason why, my lord, I'm dealing with that is my learned friend has chosen not to file a counter or very matter. They know, my lord, if they write anything about the document, they are in a suit. Only counter that has been filed before your lordship says 227 is not maintained. But once your lordship decides that 227 is maintainable, well, then they have no further argument in this case because that is the only ground that they that only appeal could have been filed in NCLAT Chennai. No 227 constitutional remedy is not maintainable, is what their contention is with their counter. Multiple times the government has given them. They have chosen not to file a complaint on merits, therefore they admit whatever statements I have made on court to this state. The only burden that I need to cross today is whether 227 is maintainable. Once I show that, CRP has to be allowed because they admit to the rest in the sense of not filing any counter. But the proposition note, we have prepared a lot of this. So how 227 is maintained?
Case laws.
These are case laws. That is the proposition note which refer to these case laws and the relevant paragraph. And the first one is L. Chandra Kumar. This is Constitutional Method 7. On the very same issue of 227 being maintainable mirror as a neutral pattern. Paragraph number 990. We can first address the issue of exclusion of power of judicial review of the high courts. We have already held that in respect of the power of judicial review, jurisdiction of high courts under Articles 226, 227 cannot only be excluded. It has been contended before us that the tribunal should not be allowed to adjudicate upon matters where the wires of legislation is questioned, and that they should restrict themselves to handling matters where constitutional issues are raised. We cannot bring ourselves to agree to this proposition, as that may result in speeding up proceedings at which was avoidable to. Such a view were to be adopted, it would be open for litigants to raise constitutional issues, many of which may be quite privileged to directly affect the High Court and thus subvert the jurisdiction of the right. Moreover, even in the special branches of law, some areas do involve consideration of constitutional question on a regular basis. For instance, in service law matters, a large majority of cases involve interpretation of articles 14, 15, 16 of the Constitution. The hold that the tribunals have no power to handle matters of only constitutional issue would not serve the purpose for which they were constituted. On the other hand, the hold that all constitution will be subject to jurisdiction of the High Court under 226 of the Constitution. Before a division bench of the High Court within which the total jurisdiction, the tribunal concerned falls will serve two purposes. While saving the power of judicial review of the legislative action vested in the High Court under 226, 227 of the Constitution, it will ensure the frivolous claims are filtered out through the process of adjudication of the tribunal. The High Court will also have the benefit of a reasoned decision on merits, which will be of use to it in finally deciding the matter. Then, para 91. It has also been contended before us that even in dealing with cases which are properly before the tribunals, the manner in which justice is dispensed by them leaves much to be desired. Moreover, the remedy provided in the current statutes, by way of an appeal by special leave under Article 136 of the Constitution is too costly and inaccessible for it to be real and effective. Furthermore, the result of providing such a remedy is that the docket of the Supreme Court is crowded with decisions of tribunals that are challenged on relatively trivial grounds, and it is forced to perform the role of the first appellate. We have already emphasized the necessity for ensuring that the High Courts are able to exercise judicial superintendence over the decisions of the tribunals under Article 227 of the Constitution. In RK Jain case, taking note of these facts, it was suggested that the possibility of an appeal from the tribunal on the question to be and better the High Court be pursued. It appears that no follow-up action has been done. No follow-up action has been taken pursuant to the selection. Such a measure would have improved matters considerably. Having regard to both aforesaid contentions, we hold that all decisions of tribunals, whether created under Article 323A or 323B of the Constitution, will be subject to High Court's writ jurisdiction under Articles 226, 227 of the Constitution. Before division bench, where it is division bench, you could serve the constitutional tribunals. Constitutional tribunals. High Court within whose territorial jurisdiction a particular tribunal falls. Another holds. Then 226, 227 will be maintainable against trial. The next judgment for the 2022 Supreme Court, paragraph number 22 to 24, and then 26. Therefore, the National Commission can be said to be a tribunal.
Yes.
So this is a national consumer tribunal against that. But specifically, this issue of 227. Therefore, the National Commission can be said to be a tribunal, which is vested by statute the powers to determine conclusively the rights of two or more contending parties with regard to any matter in controversy between them. Therefore, as observed herein above, in the aforesaid decision, it satisfies this test of an authority vested with judicial powers of the state, and therefore may be regarded as a tribunal within the meaning of Article 227 and or 136 of the Constitution of India. Also, in a given case, this court may not exercise its powers under Article 136 of the Constitution of India in view of the remedy which may be available to the aggrieved party before the concerned High Court under Article 227 of the Constitution of India. As it is appropriate that the aggrieved party approaches the concerned High Court by way of a writ petition under 227 of the Constitution. But the reason why they write writ petition is even 227s are numbered as writ petitions in Bombay, India. But here we call them as revision petitions. It's just the nomenclature that is different. Bombay and Delhi, 227 petitions are also called writ petitions along with 226. Therefore, some cases write it as revision petition, some cases write it as writ petition. But at the end of the day, it is under 226. This holds one of the frequency is written. Then para 24. But thereafter, it was observed and held that against the order passed by the tribunal, aggrieved party may approach the concerned High Court under Article 227 Therefore, again, the tribunal, which is also a judicial authority, matters between two power. 27. Para 27. In view of the above, in the present case, the High Court has not committed any error in entertaining the petition under 227 of the Constitution of India against the order passed by the National Commission, which has been passed in an appeal under section so and so of the 2019. We are in complete agreement with the view taken by time. However, at the same time, it goes without saying that by exercising powers in the convention, the High Court subjects itself to the rigor of 227 of the Constitution. But the High Court has to exercise its jurisdiction under Article 227 within the parameters within which such jurisdiction is required to be exercised. But they do not raise an objection that one of the parameters under which this 227 is filed is outside the parameters of 227. They simply say it is not maintained. Maintainability is already answered. But whether they have taken it or not, I will also answer as to how it is within the parameters. But by IA, which is the prayer that is extracted in para 1 of the impugned order, says for production of drugs. Para 8 says the issue to be decided is whether I can decide fraud. Okay, IA is for something else, which I call upon the jurisdiction of the tribunal to say, direct them to produce a document. The IA is decided on some different issue. So non-exercise of jurisdiction, which is conferred upon the tribunal, on the face of it is writ large. That squarely falls within the parameters of it. Three parameters for it: non-exercise, excessive exercise, improper exercise of jurisdiction. These are the three parameters of it. Therefore, this case squarely falls under 2. Then the next subnote 2. And I can go to 6 and then I'll come back. 6 in the proposition, Roman 6. The second aspect, even if there is an alternate remedy, 226 and 227 cannot be said to be not maintained. It is only a discretion of the High Court whether to entertain it or not. That means it is always maintainable. Whether I should entertain it or not, is a discretion of the Honorable. Now, this Honorable Court and the Supreme Court has said that once the discretion has been exercised at the initial stage, to admit the case, or keep the case pending for some time. Subsequently, after a year or after a long period of time, such cases should not be dismissed only on the ground of availability of alternate remedy, because you have to start the process all over. Having noticed that once there is jurisdiction, the discretion exercise, not to entertain or to entertain, has to be done at the beginning. But once the case is pending for some time, it cannot be relegated on the availability of alternate. That is the Roman 6 in my proposition. Project paragraph this proposition. One page. I have dealt with Roman 1 already.
Yes. For these 3 judgments.
I put after keeping the restriction pending for years, but not to decrease the petition and proper alternative.
Okay.
These are the 3 judgments. In this case, the present CRP has been pending since 2020. Admitted on 17/6. And pending since 2020. It's been 3 years. They chose to file a vacate petition and after 2.5 years, that's a different matter. But now they say we are urgent. After sleeping over it for almost a year or so. These 3 judgments at number Roman 6, which are the serial numbers 9, 10, and 11, squarely apply, stating that once the case is pending for law, you cannot dismiss it. Those judgments, I'll only show the relevant paragraph to state. Paragraph 10.
That is,
Chapter.
no, these judgments are in
The flag number will be 9.
9, huh?
9.
Okay. 9, 10, 11. Okay.
And the Roman numbers are used for each proposition. The serial numbers are used for judgment. Judgment number 9 in the it starts with the relevant portion in the para 10 in the text. Having regard to the aforesaid facts and circumstances, clear of the view that the High Court was not rightly dismissing the petition of the appellant on the ground of availability of an alternate remedy under section 68 of the Act, especially when the petition that was filed in 1988 had already been admitted and was pending in the High Court for the past more than 5 years. Since the question that is raised involves a pure question of law, and even if the matter is referred to the Chancellor and the 68 of the Act is bound to be agitated in the court by the party agreed with the order of the Chancellor. We are of view that this was not a case where the High Court should have non-suited the appellant on the ground of availability of verdict. We therefore propose to go into the merits of the question regarding the security of the party system. Specifically said, having kept it pending, having admitted it, court should not have said alternate remedies available after the people. Here is the case for 3 years. And a pure question of law. From the impugned order itself, it is clear para 1 and para 8 are self-started. But even if I go to NCLAT, etc., I'll come back again to the courts. So, the Honorable Supreme Court said that is only repetitive. Once again, you will again come back to the same place. It is on the face of it, one can see that there is no dispute and it cannot be resisted. After keeping it pending for some time and after having admitted the matter. Well, then the next judgment, judgment number 10. Durga Enterprises was Supreme Court judgment. Again, there was another Supreme Court judgment. Previous one was paragraph 3 and 4. This is one of the smallest judgments. The 2004 that is right. Paragraph 3. The High Court having entertained the petition in which pleadings were also complete.
Yes, got it.
Pleadings were also complete. Ought to have decided the case of merits instead of relegating the parties to sales. We therefore set aside the impugned order of the High Court and remit the matter to it for taking a decision on merits after hearing parties within the earliest possible period. But here also, pleadings were complete. They have been given multiple chances to file counter. They have chosen to file counter only on this aspect and not file counter. Therefore, it has been decided on its way. Cannot be relegated to alternate. Then there was the next judgment, judgment number 10. 11. Paragraph 47 and 51 are the relevant. When in the proposition votes, we have given the relevant paragraphs. Paragraph 47. We have given our careful consideration to the rival submissions made by the respective counsel. In our opinion, the High Court has committed a grave mistake by relegating the appellant to alternative remedy, when clearly in terms of the law written on this court, this was a fit case in which the High Court should have exercised in order to consider and grant relief to the respective parties. In our opinion, in the instant case, 3 of the 4 grounds on which the repetitions can be obtained in contractual matter were made out, and hence it was completely wrong to the High Court to dismiss the repetition. In the instant case, 3 grounds as referred to in Bulful Court have been made out. Accordingly, the repetition was clearly beaten up, and High Court has committed an error in relegating the appellant to dispute. Paragraph 51. Since the matter is pending for a very long time, before the High Court and also before this court, we feel just and proper to request the High Court to restore both repetitions so in the original number along with the pleadings which were already completed because the High Court to decide the same in the time bound manner preferably on priority basis 6 weeks from the date of receipt of the judgment. We make it clear that we have only extracted the excessive arbitration that is not the arbitration. One third is wrong. 27 is available. It cannot subsequently after pending will be relegated to discretion of the court. And such a discretion should not be exercised to relegate a party when it has been admitted. Then 227 directly against NCLT order. Our High Court has already decided that issue. That is that judgment number 8. What the first 2 judgments I read, it's about 227 maintenance, but against tribunals in general. Against NCLT, same question was raised, decided by this. That is judgment number 8. CRP number 5188 of 2018, which is a binding judgment. Specifically, paragraph penultimate paragraph on page number 2. That perusal of the order bears out the last date of hearing was 17/7/2018, and thereafter, Lordships have that kind of.
Yes, sir.
On page 2, second last. Perusal of the order bears out the last date of hearing was 17/7/2018, and thereafter the order of admission was pronounced on 30/8/2018. Tribunal did not even make a mention of any written submissions therein, though it invited both the parties to file the same. Tribunal seems to have merely gone by the petition and the counter. Having invited both the parties to file their written submissions, Tribunal ought to have straightaway passed the admission, therefore suffers on this account. On the above analysis, admission of the petition passing of the moratorium order was not warranted. Just to show that it's excellent. However, as the court finds that admission is passed without the pre-interference, we have directed the president is liable to be set aside of that ground. In this civil petition, the civil petition is against the very same felon. The fifth felon. But also see the paragraph first paragraph, just to show that it's the same felon. Corporate debtor original filed with the insane judges. Corporate debtor originally filed this division agreed with the order dated so passed by National Company. CP the post. Covering all cases that this. So then the next judgment, because I'll go back to Roman 2. High Court can interfere in break cases where exercise of jurisdiction is not done. Refuse to exercise the jurisdiction vested in them. There is an apparent error on the face of the record, which I have shown from this course. From if you also once I can read your paragraph, that's an established principle. When there is an apparent error on the face of it, or they refuse to exercise the jurisdiction or fail to exercise the jurisdiction, just like that. And plus 227 and read to also 226 and those are paragraph numbers also. Roman 2. Yes, I read it. But judgment number 3. The flag number 3.
Okay. Yes.
Paragraph 20. Such writs as are referred to in Article 226 are obviously intended to enable the record to issue them in the cases where the subordinate records or bodies act only without jurisdiction or in excess of, or in violation of the principles of national justice, or refuse to exercise the jurisdiction vested in, or there is an error apparent from the face of the record, and such act provision without excess resulted in justice. But here, refusal to exercise jurisdiction vested in regulation 131 allows for the tribunal to direct production, not order, which is a prayer in Roman 1. Second word, error apparent on the face of the record. Prayer is to produce a document. Tribunal thought I'm asking you to decide from today and passes an order, I cannot decide as a. And the card before the horse paracetamol in the judgment into an order, where they say, when I ask for production of the document on the basis of which fraud is committed, they say, I have to prove. But I can only prove if the document is before me. It's asking me to do something. Therefore, paragraph 20 is squarely addressed. Next judgment, judgment number 4. Paragraph 51. Under Article 226 of the Constitution of India, the High Court having regard to the facts of the case is sufficient to entertain or not to entertain a writ petition. But the High Court has discretion, High Court has imposed upon itself certain restrictions upon it. One of which is an effective and efficacious remedy. When the efficacious remedy available, the High Court will not normally exercise it. However, alternate remedy will not be a bar, at least in 3 instances, where the petition is filed for enforcement of a right where there is a violation of fundamental right of the experts of social justice, and where the orders of proceedings are only without jurisdiction or the violence of the act. But here the next word. And second, because also when I never answered the question whether it's also decided. That was not even an question and he used. Then there was the last judgment of this is para 15 of the fifth judge. That's again the Supreme Court judgment. Para 15. Para 15. After saying Article 26 having regard to the facts of the case as discretion to entertain or not to entertain, the court has imposed upon the certain restriction power which is affected by the that court would not normally decide. But the alternate remedy has been consistently held by this court not to operate as a bar in at least three conditions. Same thing. Namely, where the reputation has been filed for enforcement of right or violation of each. Where the order of proceedings has been constitutional bias. There are plethora of case law at this point, but to cut down the circle of forensic work, we would rely on some old function of the constitution or if still could be. But there are 226, 227, those are under the sense with the constitutional values, which are discretions of the Honorable Court to exercise its when especially that lordships are entertained and admitted. Having admitted it, cannot be complicated. Not the decision. It's clearly to direct them to produce it up. With that rule 131, the next Roman 3 principle is rule 131 of NCLT rules confers jurisdiction on NCLT to direct production of documents, even in cases under insolvency and bankruptcy. That also one of the issues of it is being decided. Judgment number 6. Judgment number 6. Paragraph 8 and 9. The important question, the important question involved in this application is that the applicant corporate debtor is challenging the invoices relied on by the respondent operation of creditor on ground that they are fabricated or created or forged. It is also the case of the applicant corporate debtor that there is also variation in the claim between the demand notice and the amount claimed in the petition. Here, the applicant corporate debtor is challenging the documents said to have been allowed by it. The contention of the applicant corporate debtor is that the discount was allowed between 1 and 2% and it does not exceed beyond 2%. Whereas in some of the invoices filed with the respondent operation creditor, discount went up to 4%. When a serious ground is raised by the appellant corporate debtor about the veracity of the invoices and pointed out the undisputed fact that a criminal case was filed against the respondent operational creditor, it has become necessary to direct the respondent operational creditor to produce the original invoices for which claim is raised to enable the adjudicating authority to listen same coordinate bench of the same NCLT on same case of fraud of invoices. Here it is ledger. Directs mirror that it has to be published under non-technical exercising which but it's a coordinate bench in fact the bench. Directed to produce stock. That is what color I'm asking. But the last Romans 4, even if they were to say, but by error they have not mentioned rule 131, but every rule and section will not be mentioned in the heading. General principle is one of the main section, section 65, is the violation, fraudulent application. In under that production is in the rule, under rule 131 of NCLT rule. Mere non-mentioning of the rules does not change the nature of the petition. If the judgment established principles are only giving one judgment of it. It continues from the 100 ways. One judgment, judgment number 7. At parallel. In case they were to argue that one rule 131 is not set, so but I'm covering that also. Paragraph number 8. It is well settled law that mere non-mentioning of an incorrect provision is not fatal to the application. The power to pass such an order is available. And I've already done with Roman 5 and 6. The rest of the directly, I'll come to Roman 3, which is the last judgment. In fact, NPLT can look into why this is not an issue here, just to show that how wrong that order is. Because fraud will be decided subsequent after production, not before. Of course, that will be a subsequent procedure. But to also say NCLT specifically says fraud can apparent authority. Paragraph 3 in the judgment, in judgment number 12.
Judgment number 12.
12. Paragraph 3. Learned counsel appealing of judgment number 12. The learned counsel appearing on behalf of the appealing complicator subjects the offences and penalties on the ID code can be included only by special judge in terms of Chapter 8 of Part 2 of the Insolvency Code 2016. However, we find that the fraudulent or malicious initiation of proceedings and fraudulent bank trading, etc., can be looked into by the tribunal under Section 65 and 66 of the ID Code. In any case, during the course of insolvency resolution process, validation of fraud by one or the other party brought to the notice of the adjudicating authority, it is always open to the adjudicating authority what is the appropriate authorities and parties to find out whether prima facie case is made out and hence, and the same has any effect in the resolution. And so the NCLAT, the appellate authority, in that case, also decided the next step, but after the production, will be the next step to decide on Section 65 and Section 66. NCLAT says fraud Section 65 has to be decided by adjudicating authority. That is the tribunal law. Nobody. And if there is anything, they want to refer it. Section 193 of the IPC, Amendment number 320 of the Criminal Procedure Code. Any court and tribunal can refer the cases. First, prima facie decision under Section 65 of the tribunal, which is the power. That I reiterate, is again going to be the next step after the police stop. Now, last, this is my respectful submission. I only reiterate if the party genuinely believes that the document is genuine, and they mention in fact so that in their pleading they know that they don't have a copy. Just in case when they say it now, they in fact say they have it. Not just missing another page number 206 in the notice. Page 206. And this will be counter filed by them to my application in the NCL. Now, you see Roman 2D, not Roman. Copy of the said ledger statement has been provided by corporate debtor itself to operational credit. What are we saying? I have given it to them. He is not saying he does not. Next statement, page 216. Page 216, part of the same is counted. If it is submitted, that of page 216, B, top of the page. It is submitted that a copy of the ledger statement was handed over by the corporate debtor to the representative of the operational debtor by hand at the time of the visiting of the office of the corporate debtor, wherein operational debtor requested for payment. That the said statement does not mention the name of the person who has signed the ledger, as the stamp inscribes the word authorized signatory. As such, the corporate debtor signed, affixed the stamp, and handed over a copy of the ledger statements to the representative of the operational debtor without mentioning the name and designation of the person. Two things. It says somebody claims to be authorized signatory of the respondent, which corporate debtor, sign it, give it to me without mentioning his name. Two things. It does not say who has signed it, so that nobody can be verified. Secondly, it says, I have it, but he does not produce it. Because the moment original is produced, he knows the criminal case will proceed further. Now, Lordship may simply Metropolitan Magistrate Order. IA 3 of 2023 to receive additional dollars. IA 3 of 2023.
Where do you read?
IA number 3 is a new one. This filed on 6/11/2023. Bringing on record for an order of 16/10/2023 of the 12th MM. Seeking over receipt of the property. Dated 6 November 2023. So but I mean, should don't have it. There. But the petition filed with additional branch bringing on record additional documents pending this product. What is this document? It's a para number 6. Submitted copy of the order dated 16/10/2023 passed by the Honorable 13th Metropolitan Magistrate Rajendra Nagar. It was made available to petitioner on 1/2023. The petitioner during is filing this application to bring on record the order dated 16/10 passed by sir. Lordship will see the order dated 6/15. Page 6. The petitioner is the same petitioner. Respondents followed out the same perspective, including the individual person who owned that respondent company, who are the accused. Respondents 2 to 400 are the accused. Private complaint under section 200 CRPC is filed with authority. Plus 4 to record the complaint. Yes, I will not have section 150 CRPC complaint that the complaint that is the Dutch. Having heard nothing confident of complaint on the agent of the reporting responding to the accusation to the reference have allegedly created a false document and have filed the same before NCA. The complainant has approached the Honorable High Court regarding the 6th Honorable High Court to observe in para 25 of its order that the responding police ought to have registered FIR on the basis of the complaint made by the petition. However, Honorable High Court cannot direct the police to register and FIR and investigate into matter in the petition. The perusal of the record shows that the accused persons have allegedly created ledger documents allegedly signed and stamped by unknown employees of the company and have used the same to get into the transaction. The said accusations attract sections 465, 417, 420 IS. The above mentioned facts require a thorough investigation. Further, it would be premature to determine if sections 196, 197, 198, 199 IS are attracted as the very aspect of forgery has been investigated. 196, 197 is once forgery is established, placing that before a judicial forum is 196. What the court says is that forgery has to be investigated. Basing on the result of the investigation with regard to the forgery, the application of the sections 196, 197, 198, 129 IPC would come into picture. Hence, at this stage, it is in fitness of things to refer the case for investigation for the alleged offences under 465, 417, 420. So, forgery knowledge. Considering the same, it is seen that the complainant is alleging the commission of offences punishable under suit. So, accused 822F against accused 822F. On perusal of the complaint, amendments and documents filed along with it, there is prima facie commission of cognizable offences. Complainant state to have reported the matter to the police concerned, but according to other actions, after going through the complaint and submission of the warrant, also for the complainant, this court was free that an elaborate investigation is required. Hence, the matter is referred to SHO 156 CRP for filing a report all on 15/12. So now, the even complaint is also as heard that it's a only thing that is left now is for to produce the document in terms of regulation. And not having filed a photocopy of the document in petition, the summary procedure cannot send her. I think all that is all Navadeen wants to say. That is all he wants to do, protect himself by not producing the so that forgery cannot be decided on a photocopy. But at the same time, rely on the same document before the tribunal to get me identity to state. It is not permissible. And this jurisdiction has not been exercised by the court below while referring to a prayer, but besides, therefore this CRP is liable to be allowed. But on the last petition, was to apply the prayers to match the prayers with the same NCAP. A, where it is to are directed to produce, where B is besides 65 and this is the IBC case. The moment he produces 65 and 60 players, B and C will automatically follow her because it is a first club. But he should produce that. And instead of contesting this for 3 years, but any genuine case, if you are genuine, would have said, no, it is not a full document, here is a document. I have the right, he would have said, I have filed it as an annexure to my document, an annexure. I am producing the original. That is a normal course for anybody who genuinely believe that the document is contesting this for 3 years. Even today, they don't say anything. Counter affidavit is not.
Yes. Yes, counsel.
Yes, leadership. We have already supplied all the judgment which we are relying upon to them in advance, and all the judgment which we are relying upon is also mentioned in our IA. But they have relied upon many judgments as stated before this honorable court, but they have not given any copy, nor the judgment has been written in their pleading. So my humble request is that they should supply all the judgments, scan copy of all the judgment which they are relying upon to me, so that I can revert the judgment whatever they are relying upon.
Okay, sure.
I have already supplied, but they have not supplied me.
They are admitting that you have already supplied. Anyway.
But they have not supplied. No, they are petitioners also
they are
supplied
going to. They are going to. When are you going to? Because today he will share it. Seems.
Next week it can be put up. Any date in next week.
Okay. Shall I post it on 17th?
17 November.
16?
Yeah, 16 November.
16.
20.
20.
My humble request is that the learner senior counsel dates shall be given as per convenient of learner senior counsel because it's not available on all the dates.
20. 11. Anyway, has already submitted his arguments. Elaborate.
But still you should be available at the time I am reverting.
He will be available.
On 20 November, ladies?
Yes.
Direction will going to supply there today itself.
Yes, they are going to. Need not give direction. They are ready to supply.
Yes, lady. Thank you. Highly
Right. You know, the council, the way he insists, I couldn't resist.
No, I am coming directly from the Delhi for this matter, ladies.
Yeah, I understood. Every time he says I came from Delhi, and he said I came only for this case. I have spent so much amount on all these things.
Amount, effort, money, everything is being affected.
We'll get fees now.
Highly obliged. Highly obliged.
Magistrate, then Nataka Manachana, magistrate. I'm 6 7